All right, let's head down to Texas. Judge West is getting her day started. Let's see what's going on.
For Asa Joseph Jones. In cause number 25, DCCR 0963, you're charged with aggravated assault, discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject this offer and have your case set for trial? All right, I'll get that done. As far as you know, all the discovery, you have everything? Okay.
We're not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand?
Yes, ma'am.
Okay, we'll get it set for trial. Mr. Burbank will begin preparation. Thanks.
I'll be out to see you.
And then you have Kevin Ross.
Yes, Your Honor, I just sent the paperwork.
Okay, I'll take care of it in just a second. Let's get Calvin Randall. I can take care of Calvin Randall for Mr. Eckhart.
We'll need to get fingerprinted.
We're just going on 2.
Yes, ma'am.
529. Thank you. I'll need, can you do 1 for each? It's easier for them. I'm going to mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 1530. I need to write 1530.
Correct. Yeah, 1530 is what that one needs to be. And we're going on multiple counts.
They can both be counts one on the judge. These are gonna get 10.
All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for. IATWFZ.
That's the statutory name, Judge. I think it's in a either correction facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
I've seen that before.
Weapons-free zone.
That's what it is.
Thank you, in a weapons-free zone. All right, and that is from May 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in cause number 24, DCCR 1530, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No, ma'am.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence to find you guilty, and in cause number 24, DCCR 1529, find you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do, I don't think 1529 came through. Would you? They're gonna, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. I don't know what's... All right, thank you, sir. You can go back with the bailiff. We'll get it to you.
Thank you, Judge.
Thank you, sir. And do you have Kevin Ross's stuff? Yes, ma'am. I'm sending you the last one. See, Mr. Rojas, you have Jaquan Fontenot. Good morning.
Good morning. We'll be going to counts 1, 2, and 3, Your Honor.
Thank you. Good morning, sir. Are you Jaquan Fontenot?
Good morning, yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
You will, Your Honor.
And you guys have agreed to go on.
1, 2, and 3, Judge.
Mr. Fontenot, in cause number 22-39248, I have a first amended motion to revoke your unadjudicated probation, and will he waive the formal reading of that?
He will, Your Honor.
It shows that you were placed on probation December 14th of 2022 for the offense of theft of a firearm, a state jail felony, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department July 17th, July 23rd, and August 20th, and September 23rd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of September 23rd, 2025, you were $3,505 behind. Is that true or not true?
True.
And then count 3 alleges that you committed the offenses of possession of marijuana, resisting an officer, and no insurance on September 9th of 2023 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
And the state's going to abandon the rest?
Yes, Your Honor.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Let's see, relation Mouton. Is that a
It's a competency
competency?
hearing. And then I'm gonna need a reset after that.
Okay. Good morning. Are you Relatia Mouton?
Yes, ma'am. Good morning.
Good morning. And Ms. Mouton, I'm going to take judicial notice of the court's files in Ms. Mouton's cases. We've got clause numbers 25 DCCR 0907, 1446, 1467, and 1468. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I have received that report dated September 29th of 2025. And the finding in that report is that Ms. Mouton is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Rojas?
No, Your Honor.
Mr. Smith? Then at this time, based on that report, I am going to find Ms. Mouton competent to stand trial. And Mr. Rojas, what is the announcement then?
Judge, can we get one more announcement? I'm gonna need some time to go over the rest of the discovery with Ms. Mouton.
Sure, we'll just do a normal reset. Ms. Mouton, Mr. Rojas will be out there to go over everything that he has received, and then you guys can make a decision on what you want to do with your cases, okay? You can go back with the bailiff.
Thank you.
Yes, sir, thank you.
Barbara, thank you for the $5 for Ellie for catnip. Ellie loves catnip. Io not so much. She could care less, but Ellie loves a good catnip high. We did a little research on it. It's actually about 30% of cats actually have no reaction to it. It's how it binds with certain receptors in your brain. But Ellie all about it. Io not so much. But thank you. Very much appreciate it.
Good morning, are you Kevin Damon Ross?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, Your
behind this too, I believe, 2 MTRPs and.
One new case. Okay, so he'll waive the reading of the motion as well.
We're gonna have to approve the true count one, which is the new case allegation, and then there's an agreement on all three.
All right, let me get to, let's go forward with the new case first.
And
then.
we're asking for an updated PSI.
Thank you, please.
And Judge, if you need, excuse me, more than that, all of the other counts stem from the sole incident. I think the court has reviewed the video previously of the evading. You'll recall we had an agreement of 5 a while back, and the court rejected that, understandably, just because we're doing an update. If you need more.
I don't remember the video. You have to tell me more, but
It was a very high speed evade through multiple areas of the county with the DPS.
okay. While on probation for evading. Yeah, I remember now. And what was the agreement that I had rejected before? Okay. All right, sir, in cause number 25, DCCR 1310, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 13th of 2025. And how do you plead to that charge?
June.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here, in that case, some documents on the tablet that have your signature on them. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And if I follow this agreement, I cannot give you more than 8 years. I can give you 8 years, I can give you less. It'll all depend on the information that's presented to me when we come back for sentencing. You have an absolute right to have a jury come in and do 2 things. The first is to determine if you're guilty or not. And then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right. And is that what you want to do?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Mr. Ross is not competent? All right, sir, in that case, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and we'll come back later for sentencing. Obviously, anything that you think is important for me to know, you'll get that information to Mr. Burbank, and he'll present it to me on that day as well.
Yes, ma'am.
So then we have cause numbers 24 DCCR 1198 and 24 DCCR 1199. Each of these cases, I have motion to revoke unadjudicated probations. It looks like in 1198, you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24, DCCR 1199, I also have that motion to revoke your unadjudicated probation. Shows you were placed on probation that same day in December of 2024 for the third-degree felony offense of evading arrest or detention with the use of a motor vehicle. Is that also correct?
Yes, ma'am.
So if it's unagreed, somewhat unagreed, I want to go ahead and go through the rest of those allegations. I think I need to know, if the punishment's up to me, what the pleas are, what all's been going on, not just the one new case. So I'm going to go through them all. If you need a minute to go over that with him, otherwise I'll just go through. So, Mr. Ross, both of these motions allege in count 1 that you were arrested for the offense of evading arrest or detention with the use of a vehicle on June 13th of 2025. That's the case you just pled guilty to. And is that true or not true?
Yes, ma'am. Sure.
And that's one of those, Ms. Malfino, that probably needs to be looked at being arrested for it isn't really I mean, it's true, it's fine, but that language, y'all need to get them to change that language.
Okay.
You know what I mean?
I do.
Count 2 alleges that you were arrested for evading arrest or detention. That was that same day. Is that true or not true? So that's not in the vehicle. That means that you got out of the vehicle and then ran. Is that true or not true?
Sure.
Count 3 in each case alleges that you were arrested for possession of marijuana June 13th of 2025, that same day. Is that true or not true? Okay. Count 4 in each case alleges that you possessed marijuana in violation of your probation order on that same day. Is that true or not true? Okay. Count 5 alleges that you tested positive for cocaine on a drug patch June 13th of 2025, and is that true or not true?
Not true.
Count 6 alleges that you were at a location other than your residence at approximately 1:39 a.m. on June 13th of 2025. That's true?
Yes, ma'am.
And then count 7 in each case alleges that you're a little behind in your court assessed fees in each case. Is that true or not true? Did you enter your pleas of true in each of your cases to counts 1, 2, 6, and 7 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
All right, then I'm going to find in each of your cases that, in these cases also, I have here on the tablet some documents that have your signature on them. Did you also go over these with Mr. Burbank?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And again, you understand if I follow any agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
And are these just no agreements, just to run concurrently?
Well, no, there's a cap of 8 on those.
Y'all didn't write that on here.
I thought I did.
All right, or it might not have come through. So so cap of 8 in each.
Yeah.
So the agreement is the same as the other case,
Yes.
that I can sentence you up to 8 years in prison or less, depending on the information that's brought to me in a hearing. You understand?
Yes, ma'am.
State tenders number 1 in each of those
No
cases.
objection states one in each case.
It's admitted in those cases. Mr. Ross, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations. However, I'm not going to do that today. I'm going to reset your cases for sentencing. We'll get the probation department to do updated reports, and then, again, anything that's important for me to know, get that information to Mr. Burbank, and he'll present it to me on your behalf when we come back. And if there's anything of those that you feel like proven up at that time, I think it's just mainly the drug patch and that possession of marijuana, but
Okay,
either
I'll
way.
have the probation officer here, Judge, but would you like to hear from that trooper? He's been relocated.
No, I think we're good with the others. So, Mr. Ross, I also, before you go back with the bailiff, I have in my hand jail incident reports.
Yes, ma'am.
So if you're gonna come in here and ask me to do something other than 8 years in prison and give you some kind of circumstances good, it's not gonna happen. The names you are calling these correctional officers, the rules that you're breaking, the gambling with the I mean, it's not allowed. If you can't follow the rules in jail, then what makes you think that I'm going to do anything nice for you? If you call people,
With the last one,
y'all talk to Mr. Burbank about it, okay? But the name calling, you know what I'm talking about, right? Okay. I don't care what they're doing their job, right? So they're going to work every day, they're going home, which is hopefully at some point what you would like to do in your life. Get a job, go home, be with your family. And if you had someone like you acting like that at your job, when you're just trying to do your job and enforce the rules, you're in jail. You got to follow the rules. You don't want to follow those rules, then stop committing felonies. All right, go back with the bailiff. We'll see you at sentencing.
I'll be excused.
Yes, sir.
Two cases. You're Mr. Pollard?
Yes, sir.
Pollard?
Yes, sir. The accent is on the first syllable. All right, you're charged with third-degree felony of unlawful possession of a firearm by a felon in 25 CR 138. And in 25 CR 139, that indictment alleges that you committed the state jail felony of theft. So you were looking at up to 10 years in prison in one case and up to 2 years in state jail on the other. So that's serious. What are we going to do?
Just can I have just one more announcement on him and I'll be ready. Just one.
How much time is that?
The normal, whatever your normal is.
Well, you're in the criminal district court. There is no normal in this building, in this room, as you know. Is 4 weeks good?
That's cool. That'll
Okay,
work.
good. Thanks. Chastity Rashton,
That's
get a resetting.
that's gonna be
Slate.
disposed of. I think the state is taking care of that.
This
She's
is gonna
here.
be refiled to a misdemeanor.
Okay, there isn't a lesser included we can do on this?
No, Your Honor, not with the way that it's alleged in the indictment.
Yes.
Okay.
Okay.
We'll do 1 week. They give them time to do it. That's enough time.
Well, this is just a review. You're going to end up doing it in misdemeanor court, right?
That's fine.
Is that right?
Yeah. We would just need to place this on a docket for dismissal once the misdemeanor is pled to.
What we're going to do is just put it on a review docket in 2 weeks.
That's fine.
2 weeks, so we can know it's going to be done.
Thank you.
Thank you. And Paris Ross.
That's sentence.
Get a resetting, lady, madam, right there. Thank you.
And just in sentencing now, I have just 2 character witnesses, his mother and his sister, and it's not gonna be long. But he's here, and that's Mr. Ross, and then his mom and his sister is to the left and the right. Just come on the first row. And this is sentencing. We did review the PSI too.
Number highlighted up to please.
All right, we call 2 cases. 25 CR 381. You are Paris Ross.
So
So, and you are charged in 381 with fraudulent possession or use of a credit card, and that is a second-degree felony, which carries with it up to 10 years in prison, 20 years in prison. I'm sorry. I was looking ahead. You are charged also with 25 CR 382, the third-degree felony of forgery of a financial instrument. And that carries with it up to 10 years in prison. And just like these were committed on or about the same day in October of 2023. He hadn't entered his pleas yet.
he did. Yes, he
He
did.
already did? Okay.
Mm-hmm.
Because it.
December 3rd, Judge.
Fine.
And we got the PSI.
All right, a pre-sentence report has been prepared on each of these cases. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Yes, sir.
Go ahead.
The first correction is on page 1.
Of which,
And that's defendant's version. And under defendant's version, where it has on here about denied participating in the offense, that's a correction for us because he's saying that he admitted to the offense, so that's a correction. And then the other correction, I think, would be on page 5.
Hold on, let's deal with that. First one, on,
That's on page 1, and that would be under the defendant's version where it had denied participating in offense.
he
That's a
admitted,
correction for
okay, this is line 5 under defendant's version.
Yes, sir.
Well, we got to go up some too, because he claimed in line 4 of defendant's version, the defendant claimed ownership of the items to prevent a female he was dating from getting into trouble. He goes on to state he admitted he was aware the items were connected to fraudulent activity, but denied participating in the offenses. He further stated he has learned not to take on other people's problems and not to place himself in harmful situations, and that his outlook on life has changed since the birth of his newborn child. So you're skipping around responsibility. You're either guilty or not guilty.
I take responsibility, Your Honor.
Is that your final answer?
Yes, sir.
He's going to want to correct page 5, 1, 2, 3, third paragraph, beginning in factors. And the correction for that third paragraph that begins with factors warranted, where it says maintaining that he did not commit the offense while acknowledging that he was aware of the illegal activity taking place. He's saying that he does take responsibility for the offense. So he wants to correct that sentence in the PSI.
Can he correct what is the recommendation of the pre-sentence investigation?
No, he can't correct that. He can only correct what he is.
That's what he's proposing with that last suggestion, Judge. And I would believe that Ms. Carthen is only responding to what occurred to her personally. And since I wasn't there and Mr. Adams wasn't there, I don't know how we can correct that.
Taking one problem at a time here.
Yes, sir.
The defendant admits responsibility to each of these 2 offenses for which he has pleaded guilty to.
Yes, Your Honor.
That's your final answer, correct?
Yes, Your Honor.
Okay. All right. And denying participating in the offenses, why would you say that? Were you confused or something?
No, sir.
You were being dishonest with him? With the probation office? You denied participating in the offense is what you told the probation office.
Yes, Your Honor. I was in assumption like they was thinking that we used it or did anything with it. We didn't.
Okay. You've talked to your attorney about the elements of this crime, what constitutes each of these crimes, and you either acted as a party legally to this or you were solely responsible. Is
Yes,
that
sir.
correct?
Yes, sir.
Okay, in each of these 2 cases.
Yes, sir.
All right. What was the second part?
That was the only other question.
No, the second part that Mr. Hammes has an issue with.
No, I was just trying to correct page 5.
They're trying to change the comments under the recommendations on page 5, third paragraph down. He's suggesting that the last sentence be altered because of the change in his position today.
This thing, you mean where he did not accept responsibility?
Yes,
Yes,
sir.
sir. Where it says maintaining that he did not commit the offense, acknowledging, blah, blah, blah. I'm asking that that be corrected because he's saying that he did accept responsibility. So that was a correction because you had asked me if we had any corrections.
Okay, well, as far as this court's concerned, it's never too late to accept responsibility for culpability in a crime unless it's too late after the judgment has been entered. But if he wants to correct something, the court will consider it and allow it because what we're trying to get to is what is the truth?
Yes, sir.
Is that the truth?
Yes, sir. I take full responsibility.
All right, there's an agreement that's been reached here where for each case, a cap of 4 years in prison. I guess they'll run concurrently.
Yes, sir.
All right. So we are looking at no less than 2 nor more than 4 years in prison.
Yes, sir.
We are looking at up to 4 years in prison and then found guilty, and then he could be placed on regular probation for up to 10 years.
Yes, sir.
And then there's deferred or unadjudicated probation.
Yes, sir.
Which this court can assess, which would be up to 10 years, can be up to 10 years in length. Are there any other options the lawyers can think about here in disposition?
That's it.
All right. I want to ask you about this. Were there any other issues to be dealt with the proposed pre-sentence report?
That was the main thing that I saw that I wanted to correct. Other than that, I didn't really see too many other corrections.
From state?
None from the state, Judge.
All right. I want to get a grip on one thing, criminal history here. Anybody figure out exactly how many convictions he has here? Because it's a little nebulous as I'm reading this, and it's not the probation officer's fault. It's just the defendant has been busy making bad mistakes for a long time, since 2008, actually, according to this. So we're talking about
I think if
15, 16 years.
I thought, Judge, you were going to go to the misdemeanor that purportedly received a 12-year probation period, which I don't think is viable.
Okay, we start out, we're going to start from the beginning of issues on page 2. On July 2nd, 2009, it states the defendant was convicted and sentenced to 12 months probation for driving without a valid license. Is that true? That was out of Fulton County, Georgia.
Yes, sir.
Okay.
2009.
Yes, sir. But it says it runs concurrent with the prior sentence. I don't see another prior sentence in the misdemeanor court history, but I do see one, armed robbery. In 2008, you were convicted, 1 year confinement, 9 years adjudicated probation. So that must be what they're talking about. Those two, the misdemeanor ran with that felony, I guess. Also, you had a hindering apprehension or punishment of a criminal in Fulton County, Georgia, also on September 25th, 2008, and were sentenced to 1 year confinement, probated for 4 years. And that all occurred about a year before you were convicted of that misdemeanor. Then thereafter, that misdemeanor conviction and your 2 prior felonies of armed robbery and hindering apprehension, it looks like you were convicted November 2009, 7 years probation for burglary. That was revoked and you were sentenced to 3 years in prison in 2016. That true?
Yes, sir.
And also on November 25th, 2009, you were convicted and sentenced to 7 years probation, which was revoked, and you received 3 years imprisonment on the same date the burglary revocation and imprisonment occurred. And on this one, it was illegal possession of tools for the commission of a crime. I guess burglary tools, I guess. That was revoked and you were sentenced to 3 years as well to run, I guess, concurrent with the burglary. Then kind of backing up a space. In July of 2009, you were convicted and sentenced to 5 years probation for theft of receiving stolen property. Is that true?
Yes, sir.
So that means 1, 2, 3, 4, 5 felony convictions as of 2009 and 1 misdemeanor. But then in 2016, you're convicted of 3 forgeries, sentenced to 90 days confinement to run concurrently. And I don't understand, that is under felony history, but was that a felony or were those felonies or misdemeanors? Does anybody know? He's asking 90 days confinement. I mean, that would be a misdemeanor in Texas, but then 2021, you're sentenced to 6 months confinement. And that was adjudicated for 2 years probation for selling, giving, or transporting marijuana out of California. Is that true?
Yes, sir.
And in 2023, should have been in June, you were sentenced to 15 days confinement for evading arrest or detention with a motor vehicle out of Harris County, Texas. Those are some of these are coming up under the adult felony history, and that might not be right.
My NCIC report indicates that the South Carolina offenses are felonies.
Talking about
The ones that he received 90
Harris
days.
County and California.
Okay, so the question,
Oh, wow.
sorry, I was trying to answer for your honor, is there were 3 convictions in 2016 where we received
Right,
90
out of
days.
South Carolina.
Those are all felonies according to the NCIC.
And then we've got,
I'll check the Harris County on that report.
and we've got to round out the field here, 2 more convictions, which are listed as misdemeanors. One in 2023 out of Harris County, Texas. You were convicted, sentenced to 3 days for assault of a family member. And then,
All right, Judge, I'm sorry, but Harris County,
yeah,
the original offense of evading detention was apparently pled as an eluding. So that should not be a felony. It should be a misdemeanor. That's the last one that has an offense date of June 2nd, 23.
okay.
And I'll check.
Say that again now. What did
The evading arrest detention with vehicle that was offense date 12/17/20
Yes.
was disposed of on June 2nd, 23 as a misdemeanor offense
Okay.
of fleeing a police officer or eluding, as I like to call it. That is why it's a 15-day sentence there.
Okay.
And
That makes sense.
I will check the California.
Okay. We've got I'm doing this in a chronological sequence. He's convicted in January of 23, 3 days confinement out of Harris County. That's a misdemeanor in Harris County, Texas. Then finally, he was convicted and sentenced to 13 days confinement for theft by conversion out of DeKalb County, Georgia. And that was a conviction on February 2024, but yet it states the date of offense is a decade before that happened. See, it states the date of offense was June 2015, and he was convicted 9 years later. That's weird, too.
That's Georgia's history, Your Honor. Is that correct? Is that what I'm looking at?
Mhm. All right. But we add all this up. We've got a total number of convictions here of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Is that about right? 4 of which are misdemeanors that we know are misdemeanors. Others are apparently felonies.
The California case is a felony. I confirmed that through NCIC, Judge.
Okay. Here, each of these 2 cases occurred on that we are dealing with the sentencing on, the forgery and the fraudulent use of credit or debit card, 3rd degree and a 2nd degree respectively. Is this event, each of these events allegedly occurred in Jefferson County on or about October 19th, 2023. It would have been just a few months after he was convicted and sentenced out of Harris County for that evading arrest or detention on June 2nd of 2023.
I did confirm, Your Honor, from NCIC that 9-year time frame on the Georgia offense is accurate. He had a warrant outstanding during that time frame for not appearing and finally dealt with it in 24.
Okay. All right, anything else anyone needs to change about in this pre-sentence report? Especially under the police court version, defendant's version, or any other parts of the criminal history? Yes, no? No from the defense, no from the state?
No, no.
All right. Go ahead. Again, the agreement reached is whatever sentence shall not exceed a cap of 4 years in prison.
Okay, look, I need Lawanda Cook. I'll be brief with you.
Okay, you want to
I just, yes,
present something first?
yes, sir.
Who do you call?
Ms. Cook, would you state your full name for the record?
Lawanda Baggett Cook.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand. Go ahead.
All right, Ms. Cook, you currently live in Georgia, right?
Yes, I do.
And your son lives in Georgia, right?
Correct.
Who's your son?
Paris Ross.
Oh, okay. So we don't know.
Oh.
We're just learning. I don't know your family situation. The defendant is your son.
Yes, he is.
Okay. Good.
Repeat that for me.
Would you spell your name for me?
Lawanda, Lawanda. Maiden name is Baggett, B as in boy, Aggett. Married name Cook, Cooke.
Right. So, as I was saying, you're, my client's mother, right?
That's correct.
All right. And you understand with the plea bargaining agreement today, he's been charged with 2 offenses, the fraudulent use of credit and debit card abuse, as well as the forgery of the financial instrument, right?
Correct.
And you understand that the plea agreement is a cap of 4 years where the judge could consider probation, right?
Correct.
All right. So to get straight to the point, you're familiar with your son's criminal history, aren't you?
Learning, yeah.
Right. And you're familiar with his character and who he is, right?
I am.
All right. The reason I brought you up here is that your son is your special caretaker, isn't he?
He is.
And I know it's hard for you to, talk about that, but you have a very serious ailment right now, right?
Correct.
And what is that serious ailment that you have right now?
I'm dealing with stage 4 cancer.
So you're dealing with stage 4 cancer, is that right?
Correct.
And with that being stage 4 cancer, your doctor has basically diagnosed you as dying, right?
He told me to live my best life.
Live your best life. Well, I mean, I'm just saying.
He said to go live my best life.
Live left, right.
Well, I mean, that pretty much takes a lot of hope out of things, but
No, I'm just saying.
but
I'll explain why. And with you going through.
so you are being treated
I am.
medically?
Yes.
Okay. How long have you been experiencing this ailment?
I've been sick the past 5 years, December 13th, 2020.
Yes, ma'am. Okay.
So with you being in Georgia and with the stage 4 cancer that you have, is your son a provider for you?
He's the main provider.
And by the main provider, how is he the main provider?
He's making sure the bills get paid, making sure I get my medication, making sure I get to my appointments.
So at the end of the day, we know about his history. We know about the offenses that are charged. Are you begging the court for mercy today?
I am.
And are you asking the court to put him on probation today?
Yes. Yes, I am.
And without me putting words into your mouth, I want you to speak to the judge in your own words and tell the judge why you want probation for your son.
Good morning, Judge. My name is Lawanda Baggett Cook. I'm the mother of Paris Jawan Ross. I am dealing with stage 4 cancer. They just removed 10 mass out of my body, 7 out of my chest, 2 out of my diaphragm, and 1 out of the upper right lobe of my lung.
When did you become aware you had an illness? When did the illness begin? Do you remember?
Well, I went from COVID cancer, but I just had surgery May 7th of 25.
You said it happened during COVID?
Yes.
So in 2020? Again?
December 13th, 2020.
Okay.
And Harris is my, not only is he my caregiver, he's my power of attorney. He have all the final rights and know my wishes once God decides it's my time. But I'm a single mom and clearly don't have any other person in my life significant otherwise. Not really able to work. And a lot of times can't even get up and cook and take care of myself. So he is my main source. He is, and I'm asking for mercy of the court.
So basically for you, a day in your life, you deal with the treatment of cancer, right?
Treatment, pain, sickness. I could be well right now and a little bit later, balled up in the bed. So
Right. So you can be balled up in the bed in excruciating pain
yes,
and agony, right?
yes.
And while you're in this pain, what does Paris do?
Well, when he comes from work, he's the person that prepares the meals. He will bathe me. He will even change me or get me to the bathroom if I need it. He's good with that. He's real good. But he'll send food to the door through Uber Eats when he can't. If he's at work, he makes sure some food is coming to that door for me. Food, water, anything that I need. He's the person. He's my carrier, 100%.
So here's the last question, and I'll stop. I'm the judge and the prosecutor's gonna have some questions for you.
Okay.
But at the end of the day, we're familiar with his criminal history, right?
Mm-hmm.
We're familiar with the current offenses, right?
Correct.
But at the end of the day, you need him for survival, don't you?
Yes, I do.
And with that being said, are you asking for the court not necessarily to look at him, but let's look to you as someone who's needed, right?
Yes.
And are you begging again the court for its mercy
Yes, I am.
by allowing him to have probation in spite of some of the things that he's done?
Correct. That is correct.
Thank you for your time.
Thank you.
Do you know why it took him 9 years to resolve that case in DeKalb County, Georgia? That's where you live, right?
That is correct. I have no clue why that took so long.
I mean,
I don't even remember if I can remember it.
if he's the one that's responsible for helping you out, like we were talking about, you would think he'd take care of this a lot quicker than that, right?
I imagine.
Yeah. I was just wondering. Thank you, man.
Anything else?
No, yeah, not from her.
A couple of issues I want to address on this. Number one, I heard what your mother has said, and yet with her illness, that you're supposed to be taken care of. You committed after she was diagnosed and you knew she was sick. You committed, let's see, 4 different crimes and were convicted of 4 different crimes. And yet you knew she was seriously ill. And we're talking about in DeKalb County, Harris County, San Mateo County. So this is across the country, in Georgia, California, and in Texas. Also, you have 9 siblings, don't you? 9 brothers and sisters.
3 of them, or 2 of them.
9 brothers and sisters.
Yes, sir.
That's what the probation officer wrote because you told her that.
Yes, sir.
Is that right?
Yes, sir.
Where the heck are they? You've got 9 siblings. Aren't they supposed to be doing their part to help this lady? Or have you been abandoned by all 8 of your children?
They're not mine, they're from his dad.
No, that's not what this says. Reported to have 9 siblings shared between his mother and father.
I got 2 of her and the rest of it with my dad.
This says 9 siblings shared between his mother and father. That's what the probation officer wrote. I know what that means. It's English. You have 9 brothers and sisters by her and a father.
That's correct.
Well, where are they? Why aren't they helping? The only person who's helping is the person who has committed. How many crimes did we talk about?
You said 13, sir.
Yeah, 13. But the criminal, the consistent criminal is the only one of the 9 who is able to take care of you, but yet he keeps committing crimes while you are seriously ill? What kind of responsibility is that? Pathetic. Well, you can't lever your mother's illness as a method of keeping you from being held responsible for committing 13 crimes and another one here before this court. I mean, how can it's like I'll keep committing crimes and I'll use my mother's illness as a get out of jail free card?
No, sir.
No, that's what's being said here. You have 9 siblings. They need to be doing their part naturally, decently, Christianity-like way. It's a moral thing to do. Where are they? Or have they all abandoned you, ma'am?
2 of them have not.
To have, well, then they're going to have to take care of you because he's going to prison.
So,
And he's got to be held accountable. And with his rich criminal history, his lawyer has somehow fashioned a remarkable limit of his exposure for criminality. Because after all of these convictions and committing now 2 more convictions, crimes, which are civil in nature of dishonesty, these one of these is a 20-year possible sentence. The other is 10. He was looking at 30 years in prison. And these are the kinds of cases with the rich criminal history like you have that get stacked on top of each other. But he has fashioned a deal of a cap of 4 years in prison, which is pretty good arrangement. Is there any restitution here?
No, Your Honor.
Okay.
None known, despite all those cards that have shown one.
My mother's still alive. I just saw her yesterday, and I couldn't imagine hurting her in any way. But your choices that you make, you just don't hurt you. There's the lady who seems like a wonderful person. My goodness, who has nature has dealt some difficulties, and instead of being the good son, not only to help her but to make her proud, you continue to make the same kind of mistakes you've made for going on since 2009. Today is 2009. 2008. Sorry. 16 years. 17 years. Going on 18 years of criminality. And your mother's needs you. So quite naturally, you continue to commit crimes in 3 different states. Okay. I don't feel sorry for you. I feel sorry for us. And you need to work on a whole lot, not only your own choices, but you need to quit putting yourself first. It was the great book Gail Sayers wrote, I am third. The supreme being is first, others are second, I come in third. That's why he's great. Yeah, it's a great message. You need to read that book because you keep putting yourself first when others should be placed ahead of them. You should be doing better work for others, the decent thing, taking care of family needs. Wow. Anything else to add? Anything else you would like to add, sir?
Judge, if prison is going to be in, Judge, I would ask that on 4-year cap that you do 2 without having any definitiveness to his mother's condition. At least I think that would at least give him a chance to get out and to still be with her in her final days. And
You're, okay, I'm
that's,
sorry. Go ahead.
that's why I was asking for I was asking
Okay.
for that number.
I can't help but say that's not the way sentences and the justice system and the laws are supposed to work. Essentially, it's the circumstances of the offense and criminal history. He has dealt with his mother's condition for several years, and yet that has not deterred him. I'm worried about the community at large being subject to more criminality. His mother's illness and her need of him to help her. He has elected to continue to commit crimes of dishonesty, among other things, than do the right thing morally and decently. And the community is best served overall for everyone. Even though your mother needs you help, you should have been helping her when you were committing these crimes, when you knew she needed help. Shame on you. If nothing further by any party, I'm going to find you have pleaded guilty in each of these two cases, sir, in 25 CR 381 and 382, illegal possession and use of credit or debit card abuse, and a second degree felony and the third degree felony of forgery of financial instrument. You have pleaded guilty in each of these felonies voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 4 years. These two sentences shall run concurrently. And I hope that your mother is able to get the help that she needs from other members of the family, the 8 other siblings, because you have failed her responsibly. You have failed by failing to follow the rules of law and by continuing to victimize other people. Shame on you. And I wish the very best for her. I know you better than you have acted over these 13 convictions for 20 some odd years. Anything else to add? That is all we are in recess on this case. Thank you. Here's this.
Thank you, Judge.
Let's go down to Louisiana. See what's up with the board today.
Morning, sir. This is the Committee on Parole is called to order. The date is January the 21st. The time is 9:08. My name is Carolyn Stapleton. I will serve as the chairman on today's panel. We'll be joined by Zoom, Mr. Steve Prater and Ms. Jerry Ledoux. Headquarters staff, will you please introduce yourself for the record?
Devin Cavalier.
Carl Williams.
Francis Abbott.
Okay, and today's remote location is going to be at Rapides Detention Center. Staff there, will you please introduce yourself for the record? Is there any staff in there with you, sir?
Yes. Sergeant Steinman.
Okay, Sergeant?
Yes, ma'am.
Sergeant Stone, you said?
Steinman.
Okay, thank you very much.
Yes, ma'am.
Okay, for the record, Mr. Williams, will you introduce yourself and give your DOC number, please?
My name is Clem Williams. I don't know my DOC number.
Okay, that's okay. I've got it right here, no problem. It's 793-125, okay?
Hey, thank you.
Okay, you're more than welcome. Okay, well, I'm gonna read some information. And it's gonna, and then at the end, you can verify that it is correct, okay?
Okay.
I'm just gonna repeat a couple of things you just said, that your name is Clem Williams II, and your DOC number is 793-125. You're a first-class offender. Your offense is aggravated second-degree battery. You were sentenced to 6 years hard labor. Your parole date is December the 4th, 2025. Your good time date is July the 10th, 2026. You have a full term date of January the 10th, 2028. Is all of that correct?
That's correct.
Okay. Will you please tell us why are you incarcerated and why should you be released early?
I know I'm not all the way there since I've been in jail. I have gotten treatment. I know what I did was wrong, and I'm sorry. If I could change it, I would. And I know that if I'll given another chance, I would do good.
Okay, sir. All right, Sergeant, do you have anything or any comments you would like to add as to his time that he has spent in jail there?
No, ma'am, we haven't had any problems with him or anything.
Okay, you've had no problems.
Yes, ma'am.
Okay. Well, today you don't have anybody in support for you, but you do have opposition. And that would be District Attorney Philip Terrell, and you can get up and speak.
Yes, ma'am. Thank you, Madam Chair.
Uh-huh.
Members of the board, thank you for the opportunity to address you. I know each of you have thoroughly reviewed this case, so I'll try to be as very brief as I can be. The facts in this case are fairly heinous. Mr. Williams was arrested for attempted second-degree murder, and he pled guilty to aggravated second-degree aggravated battery. Sentenced to 6 years in plea bargain. Of note, as referenced at one point, the facts were that Mr. Williams was a patient at Pinecrest, at Pinecrest State Hospital. And he had attacked another patient there, and he was after detectives reviewed the video surveillance, it occurred after the other patient you did an obscene gesture to Mr. Williams. Mr. Williams stabbed him in the back of the neck with a pit cone, a metal pit cone, repeatedly, at least one time. And last time it stuck in the other patient's neck. Staff broke them up, and as members of the staff were attending the other patient, the victim, Mr. Williams broke away from the staff that was trying to restrain him and pummeled him about the head and shoulders and was trying to hit the pick, according to the staff, according to the police report. I know that y'all have read all that. Mr. Williams said, and there was some question, there was a sanity commission filed by his counsel, and he did go to the DOC facility and was examined there, and it was determined by the a sanity commission that he was both able to stand trial and not mentally incapable legally at the time of the commission of the crime. Mr. Williams admitted to both the Pineville Police Chief, Pineville Police detectives, and to staff that he intended to do it, which was apparent from the video, that he would hurt somebody again if he did not get what he wanted. He wanted to be moved to a facility or a halfway house near New Orleans. And he told numerous times and I won't bore y'all with all of them. Numerous times he said that he would, when he doesn't get what he wanted, he would hurt somebody. In fact, he said in response to Dr. Woods, and Dr. Woods, as Mr. Williams told Dr. Wood, who I presume is a DOC, but let Clem tell you all something. I will keep hurting people until I get what I want, and I don't need any more warnings. And at one point, he told Mr. Williams told the doctors, I don't give an expletive no more. You can send me to jail. I told Connolly that I was going to do it, going to jail for the fourth time, this time for attempted murder. Then he says, in closing on in that interview, I don't want to be here. That was a warning. I talked about stabbing that expletive in the neck, and I wanted that expletive since yesterday. I asked Mr. Williams if he was trying to kill the victim. He stated yes. And this is a police interview with a pilot detective, I'm sorry. So he said, Mr. Williams, why did you do that? He just bothered me. I wanted to teach him a lesson. So the diagnosis that I want to point out to y'all, I know that the gentleman's mental state was an issue. I know that y'all may be thinking about that. As one final point, Clem's intellectual disability is correlated with, but not the cause of challenging behaviors. Clem's presentation is most consistent with his diagnosis of antisocial personality disorder. Specifically, Clem exhibits a lack of remorse, aggressiveness, impulsivity, and disregard for the safety of others, which supports a diagnosis of antisocial personality disorder. This critical incident is of salient severity, indicative of Clem's focus on achieving a discharge from future arrest. And once again, to me, the part that's most telling is Mr. Williams' statement in writing. But let Clem tell you all something. I will keep hurting people until I get what I want, and I don't need them anymore. Ladies and Sheriff, I would submit to you that we're 2 years into a 6-year sentence of a very bad crime, and Mr. Williams got a pretty good deal. And he got that pretty good deal because of various factors. It was clear, we had a victim that it was on video, but we had a victim that has a severe disability, so can't testify. And there was the obvious element of the mental situation. So we did a plea bargain, and he got a good deal. 6 years for this very aggressive and pretty much heinous act, which had the police arrested him for attempted second-degree murder, which would put him in prison for 50 years if we would have. So in any event, I would submit to y'all that he's only been in jail 2 years. I would submit to you that's not enough time for number one, we need to protect society. We need to make sure that he's ready when he gets out to become a productive member of society and not be the person who says if Clem don't get what he wants, he's going to hurt somebody else. So in summary, I would submit that it's not time for him to be paroled for a variety of those factors. And I appreciate y'all very much letting us come address you today. If there are any questions from any of the board members, I'll be happy to try.
No, I mean, I noticed the very same statements that you gave me, and I have them marked in the police report that I have too.
Yes, ma'am.
I don't have any questions. Do either of my colleagues have any questions for the DA? No, Ms. Ledoux doesn't. All right, well, we really appreciate it.
Thank you so much.
Thank you. Okay, the case has been assigned to me, So I will conduct the interview. And then later I'm going to cast the first vote. I made note of exactly the same things from the police report that the DA did too. That you were going to continue to hurt people until you got what you wanted, and you didn't need any more warnings. And you told him that you were going to do it, and you did go back and try and continue to hurt him after staff was trying to help him, and you had stabbed him. And then when you were asked why you stabbed him in the neck, you said that you wanted to teach him a lesson, and that you intended to kill Mr. Khan. Well, the other inmate or the other person. Did you intend? And you said yes, that you did, and that you tried to kill him because he flipped you off. Does that sound familiar to you, sir? At the
Yes.
time?
Yes, yes.
It does, okay. Okay, so you heard the DA, I've got the same report. Do you have anything you'd like to add to that? Or take away, or?
No.
At the time.
No.
All right, well, I'm gonna ask my colleagues. Ms. Ledoux, do you have any questions?
No, ma'am, I've reviewed the file and listened to the testimony.
Okay, Mr. Prater, do you have any questions?
No questions.
Okay, well, at this time, we're prepared to vote on the lead vote. So, I'm gonna deny your request for parole, and on the facts of I consider you a continued public safety. You have only served 2 years of the 6-year sentence, which was very like what, according to your words at the time, was actually attempted murder. So not enough time for a deliberate crime of violence. Number 2, law enforcement and judicial opposition completed. And number 3, at the time I saw no lack of remorse for the crime. So, Ms. Ledoux, do you have anything?
I concur, Ms. Stapleton, and my vote is also to deny parole.
Okay, Mr. Prater.
My vote is to deny parole based on the degree of violence, not enough time served, a danger to society, and law enforcement opposition.
Okay, the outcome, Mr. Williams, is that today your request has been denied. And the time is 9:22, and we will be closing from this facility.
Melissa Devaney.
Okay, all right. Miss Combetta, and I'm correct there?
Yes, ma'am.
Okay, Ms. Combetta, I'm gonna read some information for the record, and at the end, you'll let me know if everything is correct, okay?
Yes, ma'am.
All right. Chantel Combetta is your name. Your DOC number is 786-864. You're a first-class offender. The offense is Livingston Parish 44069, attempted trafficking of children for sexual purposes and promoting prostitution. Your sentencing date was March 11, 2024. Your sentence was 5 years, DOC hard labor, suspended all but 3 years, and then 3 years supervised probation. Your parole date is March the 20th, 2026. Your good time date, you're not eligible, and your full-time date is December the 20th, 2026. Is that correct?
Yes, ma'am.
Okay. All right. In your own words, will you tell us why you're here today?
To be granted parole.
Okay, want to tell us, in your own reason, well, you said to be granted parole, but why are you incarcerated? What brought you to this point?
I was hanging with the wrong crowd and led me to do wrong things, and I made a mistake.
That's very vague. Anybody could say that. What happened?
They had we had a hotel room, and they had a person prostituting out of it, and the hotel room was in my name.
So you're saying you didn't have anything to do with it?
No, ma'am. I take full accountability for my actions.
For your actions that you rented a hotel room?
Yes, ma'am.
Staff, do you have any comments?
Chantel has been in all kinds of courses, even though she doesn't get good time credit while she's been here. AA, Bible study, living in balance, celebrate recovery, life's healing choices. She's worked in the kitchen for a long time, and then she also works at 911 and cleaning and commissary for us. She has no disciplinary record.
Mm-hmm.
As far as she does anything we ask her to do, she's no problem at all.
Mm-hmm. Well, that's speaks very highly of you that you wanted to be a part of those classes just for your own self-improvement. I'm glad you let us know about that. Okay, at this point, we're going to listen to supporters for you, which would be Leah Joseph, your sister.
Good morning.
Yes, ma'am. Good morning to you also.
How are you?
I'm fine.
So she's my sister, and she has my full support if she's able to come home. I think she learned from her mistakes. She talks about all the good things she's done while she's there. She has a job lined up for her. She's a very good person, just was under the bad influence of just being around the wrong crowd. She has a job lined up. She would love to be home around her kids. I think she would be going to church, be involved in the community, and she has the support of me of helping her get a job or a TWIC card to get into a job, help with her children, find her a place to live.
She'd be staying with you?
I don't believe at the moment she had already made arrangements to stay with our mom, but if she was granted to stay with us, if she was allowed to stay with us, absolutely she can stay with us.
Family.
Yes, ma'am.
Okay. All right. Thank you very much.
Thank you. Yes, ma'am.
Okay. At this time, we do have opposition, and we're going to start with opposition would be, I'm just going to read the names. Tamika White with the JDC, the DA's office, 21st, and then Michelle Sparks. She is with Tamika, and Kathleen Costa. She is there also with the JDC. And speaking today will be Alexis Taylor. She is the ADA at the 21st JDC. Ms. Taylor.
Good morning.
Morning.
We at the DA's office are opposed to her release. She was responsible for escorting a 15-year-old child to a hotel to perform sexual acts for money. It is my appreciation that the acts were scheduled through a website by the defendant's boyfriend, and the defendant would escort this victim to the location to perform the acts. And just going through the report, the victim stated that she tried to have the defendant, Chantel, not bring her to any more hotels, and that she did not want to keep doing this. However, the victim stated that Chantel made her go to the comfort suites and stated to her that she did not have choices anymore and that she had to make money for her and her boyfriend. The victim stated that once Chantel dropped her off at the hotels, she would leave her there and would not return until after all the clients were seen. So based on that set of facts, the victim's young age, the state is opposed to the defendant's early release.
Yes, ma'am. Thank you very much. Chantel, your case has been assigned to me, and I'm going to conduct the interview, and I will later cast the first vote. Well, you heard what the DA just said. What do you have to say about that?
That I'm deeply regret that the actions I have caused, and apologize for any of my decisions that I had made, and that I'm sorry to the victim and their family, my own family, and even the community.
Well, you know, when I asked you earlier to say in your own words what happened, you didn't say any of that. Just that you made a mistake and you were sorry. Is there a reason why you, right now, the victim said that she asked you not to make her do it any longer? Can you expand on that? What was going on that caused you to make her do it anyway?
It was a bad spot, and it was not my boyfriend defendant. It was nervous. A man. He basically made me make her do it, and I went along with it. And I know I was wrong for the crime that I have committed. And if I could take it back, I would tell her that I'm very sorry, and I apologize.
Oh, the gravity of human trafficking is these are all strangers.
Correct. It's a serious crime.
It is a serious crime, and at any time, the child could have been beat up.
Correct.
So, I mean, human trafficking leads to a litany of other things. It's bad enough when, you know, when you have rape of a child, a lot of times it's a family member, somebody they know well, and that's heartbreaking, and that's frightening also, but this is terrifying what this child went through. So did the child stay with you, or did she go back home, or how was that?
She was considered a runaway, and her mom had let her stay with me. And she went back home to her parents. I think she went to a juvenile helping center to get help. I'm not really sure. I had a stay away order, so I didn't go in contact with her in here or anything.
Well, how was it found out that y'all were doing this?
They had got caught up in the hotel. I think other people from the other rooms have reported it. And when I had got pulled over, they had let me know that I had a warrant. And I had served 4 months in 2022. And I had got out. They let me out on an OR. And then I just went to court every month, or whenever they had court, I went for like 2 years. And then I had to turn myself in after my plea. And I've been incarcerated since.
The victim feels like your boyfriend played a significant part in this. As far as she feels like that you didn't know how to get out of it. Was that true, how she felt?
Yes, ma'am. I was also pregnant at the time, so.
Did see that. It was with his child?
Yes, ma'am.
Okay. All right. You should know that you had support letters from family, 7 of them from work. You had one. So and then there was another one. So you had a total of 14 support letters. But total opposition from law enforcement. The sentencing judge had no comment to your release. I will turn it over to Ms. Ledoux. Did you have any questions?
No, I just would make note that for release, an inmate has to have pre-release and substance abuse completed. And we don't have the substance abuse shown that it's been completed. So that would not, she would not be eligible based on those things, although we could, she has a full term date in December. So I don't have any other questions or comments.
Mr. Prater?
Yes, what's the status of Joshua Johnson's charges? Do you know that?
Are you asking me, sir?
Yeah, what was?
From what I know, he's never went to court for it. I'm not really sure. He's fighting another charge in another parish.
Okay, are you willing you gonna testify against him if it comes up, or y'all still have a relationship?
No, sir, I don't have no contact with him. But
Have you had any contact with him since you've been in jail?
No, sir.
Okay. That's all the questions I have.
Okay, you can close with telling us anything else you would like us to know. Consider, Ms. Combetta.
During my time in incarceration, I have made personal, emotional, and spiritual changes in my life. While I can't change the past, I am committed that I can show and prove that I can be someone better. Even though I'm not eligible for classes, I still took them, and completing the programs, it showed me that I'm capable of being a better person.
I do have one question for staff in the room, and Ms. Ledoux brought it up. The eligibility for parole is that we have the pre-release programming and substance abuse treatment. Is that offered to her? Was she just not? I see where she took so many other classes.
No, ma'am, we don't have that here. I know in the past when y'all ran in parole that y'all they were transferred to the women's prison to complete the reentry and the substance abuse over there. I think in St. Gabriel's.
Mm-hmm.
We had one maybe in December that went for just that.
Okay, and you're going to be getting out in December of this year, so that would, Ms. Ledoux, that would fall in line with the time frame if we had her transferred. It's like 100 hours, right?
Yes, and yeah, I can't really speak to that. I'm sorry.
Okay, I understand. What? Okay, all right. So I'm ready to vote at this time, and
Could I ask?
Yes, please. Yes.
I got just a couple of questions that really, because it's a tough case. Did you know this? Did you know her age? That she was underage?
No, sir. She had said that she was 18, and I found out her age when we were at a hotel and her mother had seen her. And that's when I found out she was a runaway, and her mother told me her real age because they wanted to press charges. But her mother said if I meet her and talk with her, she would have a conversation. And that's when she told me her age and everything.
Did you ever have her used after that?
No, sir.
Okay. How old were you at the time?
I was 29 or 28, about 28. turning 29.
Okay, so you were grown and you couldn't tell that she was only 15, or how old was she when she started?
She was 15 and she was going on 16. Her mother told me she was 15.
Okay. Were you doing drugs at the time?
No, sir, I never did drugs.
Were you drinking a lot?
No, sir, I don't drink.
So what excuse do you give for pimping this girl?
More so, it was more part of it was me, but more so of the man making me. I was just in a rough situation with my kids' father.
What I have to decide, okay, I had to decide in the parole board, each one of us has to decide different things. I'm trying to decide if you get out and this guy calls you and wants to go out on a date, even though the staff and everybody you work for now thinks you have really, they probably would have said that prior to you. If you weren't doing drugs and weren't doing alcohol and they got to know you, you were probably a nice person back before you met this guy. Is that correct?
Correct. I was different from when I met him, but I have no contact and I'm not planning on having no contact with him.
Well, you're not planning on it, but you might. In other words, are you so easily led that if this guy calls you, you'd be willing to do what needed to be done?
No, sir, I wouldn't.
How much more time you got?
To December 20th of 26.
Okay, so you're looking at 11 more months.
Yes, sir.
10 more months, really. Okay. That's all I got.
Yeah, and I would like to expand on what Mr. Prater said. In our synopsis of the arrest report, it has that that you were responsible for picking up different females, and that was one of the reasons why the phone call was made, because they saw all the trafficking going on in the room. So we've got the one child, but as far as I can tell, you were very involved in picking up different females and causing them to do this. Is that correct? It wasn't just the one child.
No, ma'am. There was another. He had a girlfriend that she was 24.
Mhm.
Her and then the 15-year-old. There was no one else.
Who you knew to be a runaway, and who we know she asked you not to make her do it anymore. Am I
Correct.
correct?
Yes, ma'am.
What? And the reason you say you did it is because you were in a rough spot. Am I correct about that?
Yes, ma'am.
Got 11 months left. Okay,
Let me ask.
Yeah, okay, go ahead.
I keep getting these questions that come up. So Joshua had, that's his name, correct? Your
Yes,
fellow
sir.
you were going with. And he had another girlfriend?
Yes, we were in the part of separating. When I had got pregnant, I was 3 months with my little girl, and we were trying to separate. And he didn't want me to leave him. And I found out that he had a girl, which was his girl. Come to find out to be his girlfriend. So I was
You
putting on.
Did you stay with him after that?
No, sir. I had got 2 jobs and was going my own way.
But you were with him the night you were arrested, correct?
Yes.
But you
sir.
said you had already left him by then.
Yes,
So if
we
you had
had,
left him, if you had left him, if you had left him mentally, but you were still with him physically, what made you do what he told you to do?
more so nervous, scared.
How much money were you making?
I really wasn't making anything. It all went to him.
It all went to him and you
Yes,
kept doing it, even though you decided to break up, even though you knew he had another girlfriend, and you continued to do it free. Is that what I'm hearing?
yes, sir.
That doesn't make sense to me. That he had some kind of magnetic hold on you, and I'm fearful he will still have it if you're that weak. Okay, that's all the questions I got. I'm sorry.
Yeah. Are we ready to vote, panel? Mr.
I'm ready.
Okay, and Ms. Ledoux? Okay,
Ready.
this time, you have followed through with some other classes. And, you know, I'm going to try to see if you can be transferred for your pre-release programming and your substance abuse treatment so you can get that finished before December. But I cannot agree to granting your parole request. The crime was just too serious. It was a runaway. She really didn't have anybody to turn to. And you said terrible choices, but you clearly made them of your own volition. You chose to make those choices. I mean, he didn't hold a gun to your head or anything like that, based upon what you said. And you said that he hadn't even been charged with anything yet that you're aware of anyway. So my vote today is not to grant your parole. I'm going to request that they transfer you to a location where you can get your pre-release programming and your substance abuse treatment. You only got 3 years for a horrific crime. So I guess that was through a plea bargain. Is that correct?
Yes, ma'am.
Yeah, so your plea bargain, 3 years, so I feel like you should serve your full term. And then I'm gonna request, if at all possible, that you be transferred to a location where you can get your pre-release programming and your substance abuse treatment. Mr. Prater, what is your vote?
Concur, deny, terrible crime. I'm really fearful that she's gonna continue if she doesn't get some real help and some real support. This was a terrible crime of a grown woman allowing a juvenile to go into prostitution regardless of her status. And I appreciate the assistant DA's comments. And for that reason, my vote is to deny.
Okay.
My vote is my vote is to deny parole. I wish you well.
Thank you.
Hey, ma'am, so today your vote has been denied. I mean, your parole has been denied.
Okay, you were, Mr. Cruz, in 25 CR 804, Alejandro, you were charged with the state jail felony of burglary of a building. If convicted, that carries with it up to 2 years in the state jail, which is not a good thing. What are we going to do today?
There's just an initial, I still have the meeting on him if I have 4 weeks to get that.
Yes, July. He was indicted in July.
This is my first appearance with him.
I don't know, but it shouldn't take. Have you moved recently?
I was in custody in LA. I was in custody
Where?
in Mercer County. Sir.
To when?
About October.
For what?
The
For a charge over there?
Yes,
What was it?
the same charge.
So what happened in the case? Did it get
sir? Yes.
it get
I'm sir.
disposed of?
Yes.
Okay. You know that?
I wasn't aware of that.
So
This is my first appearance, which is
yeah, I'm talking about over there, because I don't see a criminal history here, but you were convicted in that other one?
yes.
What was it? What was?
State jail. 1244. They gave me
Oh,
1244.
1244. Okay,
Yes.
but it's still a state jail
Yes,
conviction,
yes, yes.
but you received punishment as though it was a misdemeanor.
Yes.
Those are good things if you can get them. And what was the crime?
Same-
Burglary of a building?
same-
Was it this? It wasn't the same event.
No, it was.
It was a different
two
event.
different
Okay.
locations.
Okay. Miss Time, you gotta get a resetting. Miss Time.
Yes.
Here, sir.
Chester Fobbs, please. FOBBS.
Oh, sorry, here. Yeah.
I didn't want to read.
Are you Chester Fobbs? I'm calling cause number 25, CR 1663. And you are charged here by an indictment with failure to comply with sex offender registration, which you were required for life, right? This, you have to do that for life. And this is a third degree felony. That's why you have to be very cautious and ensure that you register regularly and timely. Because if convicted of this, you were facing up to 10 years in prison. Yeah, that's the way it is. It's a third degree felony for not registering properly. What are we going to do for that?
Judge, I need some time to go over the media with.
It just got indicted
It's new.
a couple of months ago, so I'll give you 4 weeks on this. Are you registered properly now?
Yes.
I mean, there was a hesitation. You're nodding vigorously.
Yes. This
I
morning.
know, but we gotta verify.
Yes.
Does state know the answer to that?
I don't know off the top of my head. I can look into
Can
it.
you look? I don't want him leaving until I find out if he's registered properly right now. Okay? No, it's a crime.
No, I
And
understand.
it's
Judge.
going to affect his bond if he's not. But he's got a duty to do it, and he's got to do it. And I don't want you to leave until I know whether you have been properly registered and complying with this registration. Because every day it's a crime.
Yeah, change of address.
Is that what you did?
Yes. It gave him to mistake.
Okay, let's just verify it before Mr. Fobbs leaves. Okay, don't leave, make sure it's. We'll put this on the side. Here, I'll need this on the side. Remind me, Mr. Fobbs. I mean, that's
The reset.
legislature makes that very important. And when you get caught not registered, the first thing you have to do is register.
Yes, sir.
If you're not in jail already.
I'm sorry, I need you to sign right there on the high level. That's for me.
Judge, you want me to sit over here while they do that?
Yeah, I can see it. Thank you. Ricardo Kelly. Ricardo Kelly, come forward, please. '23 CR 2261 is called. You are Ricardo Kelly?
Yes.
Wow. You were, this is your first appearance in this case, right?
Yes, sir.
You were indicted over 2 years ago. You must have moved around.
Yes.
You're still at 11514?
No.
So what's your address?
947 West 13th Street. Hold on, Texas.
Hold on, Tex. You're shooting fast here. Seven,
640.
I have 947 West 13th.
Yes.
Okay. You're no longer at 11514.
No, sir.
That was it. That was the problem.
Yeah, no, so like 8 things.
Okay, once again, this carries with it if convicted up to 2 years in the state jail. I don't see any prior convictions on this. Are you getting a lawyer?
I was supposed to be assigned a court appointed lawyer.
I'm sorry?
I was assigned a court appointed lawyer.
Why? I've been working since the day I turned 16. I paid my own way. Everybody else, if I can do it, anybody can do it. The people, the taxpayers are not going to pay your way. Are you able to work? Okay, I expect you to work and pay for your lawyer. That's what we all have to do. You're not going to rewrite the system. You've got to go and get a job and pay for your lawyer. Now, we're going to get you somebody appointed, but you're going to pay for the people of this county to represent you. They're the ones carrying the burden, but you're the one charged with the crime. They shouldn't be. Is that too hard to figure out? It's really not. You made a mistake, according to the grand jury. Just like everybody makes mistakes, you got to fix it. And it's your responsibility, just like it's mine. And I have to put gas in the car. The person parked next to me doesn't pay for it. We've got to take care of our own obligations. And this is an obligation. I expect you, if you're able to work, to go out, get a job, and pay the people back who are going to be footing the bill for your representation. You understand? That's not, it's just the way it works everywhere. This not a free ride system. Somebody's paying for everything. And it's the taxpayers included, which you are included in that. That's why you got to do your part like we all do. When was the last time you were employed?
I'm employed.
Oh, good. What are you doing?
I'm a ship manager.
Okay. Okay. Have you ever worked with them before?
Yeah.
That company before? They have a pretty good deal going. And you're a manager? Well, you've got responsibility. Okay. What do you make an hour over there?
$12.
I'm sorry?
$12.
$12? Okay, that's 25. That's 25 annual. One thing you need to do, he needs to fill out one of these income financial forms. That's not in here. And that has to always be in here when somebody is not represented by a retained lawyer. So you're going to have to fill that out. I'll look at it, and we're going to get you some help until you can hire somebody. We're going to get you some help to represent you, one of the public defenders here. Okay. And we'll introduce you to him. Fill that out first, though. Okay. Right over there in the box. Okay. We're going to just reset this for a review in about 4 weeks.
Yes, sir.
Okay.
All right, friends, what do you say we try something new, something different? So we're going to go to Dickinson County, Michigan. This is the Iron Mountain area, so like the very west side of the Upper Peninsula. This is Judge Julie Lacoste. Let's see what she's all about.
Carlson, prosecuting attorney's office, is not here this morning of their own choosing. We're set for a sentencing. We did get the assessment, excuse me, to that extent, it's updated, recommending an alcohol highway safety program. Do you have that update?
I didn't see it, Judge, but I was informed of the same from the probation department.
All right, I have reviewed the assessment. It was done by Vanessa Larson. In respect to the matter, then, is there anything factually inaccurate in the report?
No, Your Honor.
Anything that you need to update or correct?
No, Your Honor.
Have you been over it with Ms. Kitzman?
I have, Judge.
All right. Anything you'd like to tell the court before the court imposes a sentence on behalf of Ms. Kitzman?
Judge, if I may just briefly.
You may.
Your Honor, thank you. Your Honor, Ms. Kitzman appears before this honorable court. As the court can see, for a first time interaction with law enforcement and a first criminal conviction. Your Honor, I referenced it to Ms. Kitzman, and I've heard you say if I had $1 for every time you said it, and probably I said it as well. Good people make bad decisions. Ms. Kitzman was out this night and celebrating, and things got away from her very obviously. Your Honor, she consumed much more than she intended. She consumed much more than she should have to drive. Your Honor, frankly, things got away from her. But the other thing, Judge, and I was chatting with her about this as well. When we see high BACs, it causes us pause, causes us some concern. And I've discussed with her that concern because of the high level. You know, even though perhaps that night she made a bad decision, there was a history that led up to it to be able to get to that level. And the way I've explained it and chatted with her, we've had discussions about it. Sometimes these things happen, and it allows us to take an inventory of kind of where we're at in our lives and how we got there. And I've portrayed this and talked with Ms. Kitzman. We've discussed it and taken this as an opportunity to do an evaluation and take a step back. She's going to have to do that because her license is going to have these restrictions with the high BAC, as the court knows and she knows, she's going to have a suspension followed by a full year of having that interlock in her car. So she'll have a daily reminder every time she starts that vehicle of her actions that evening and how things got away from her. And because things got away from her, she has ramifications, Judge. Thankfully, nobody got hurt, her included, her fiance as well. There was a parked car. Nobody was in it, but it was damaged, and it could have been much worse. And that was the first thing that she made the comment to me when she called me was, thank goodness nobody got hurt. I can't believe I'm in this situation. I don't know how I got here. This was Your Honor, so all that being said, I think that the lack of criminal history, she is not a 21-year-old young lady making youthful, foolish decisions. She knows better, and this is just simply an opportunity for her to make amends with herself, the community, this court, her family, and make better decisions in the future, because next time there will be bigger ramifications, including mandatory jail, license sanctions, but also if somebody gets hurt, the fallout could be much, much more dramatic. So, Your Honor, based upon the lack of criminal history, based upon the isolated circumstances, and I think also importantly, I watched the entire video, of course. She was very cooperative with the officers, very respectful, very courteous with them. She acknowledged, as noted in the incident report, that she drank too much alcohol, that she shouldn't have been driving. So I think she immediately realized her bad decision making that evening. Your Honor, I think the recommendations are appropriate. I think they're in line with what we normally see with a situation like this on a first offense. We'd ask the court to follow the recommendations. I anticipate that the court would adopt a sober link based on the level of the BAC. I would note, as the court notes, she will have the interlock in her vehicle, which is separate from this. But if the court perhaps considers that a bit, I don't know if the suspension has started already, but she will have a sober link in her vehicle as well. So I'd ask the court to take that into consideration when handing down its ultimate sentence. Thank you, Judge.
Yes. Ms. Kitzman, anything you'd like to add before the court imposes a sentence?
No, Your Honor.
All right. All right, then, concerning the matter, Ms. Kitzman, I think your attorney has hit the nail on the head in respect to the matter. You're extraordinarily lucky that nobody was injured. Your fiance wasn't injured. Nobody was in the vehicle that you hit. But as I read the police report, you were quite well inebriated and really should not have been behind the wheel of the vehicle. So you have to make smarter choices from here on out, especially working in the field that you do. You're going to have to abstain, not just while you're on probation, but you've got to make sure that you don't make this mistake again, because 1 is tough, right? 2 is almost insurmountable at times, especially if you value driving privileges. So in respect to the matter, then make sure that you abide by the terms of your sober link. just the fact that in a environment like this, you're no longer able to use your remote starter because you have to be there to blow into that machine. So it's all, it's all part and parcel of the hole that you've dug. Now, this is not a hole you can't dig out from. This is something that you pick yourself up, you brush yourself off, and you move forward having learned some lessons in life. What I like to say is that nobody's perfect. We all make mistakes, but it's how we fix our mistakes that define us. So make sure that you just be smarter than this and that you make better choices. All right, I know you can do that. All right, I think the recommendations are appropriate. I'm going to place you on a 9-month term of probation. There's a $300 oversight fee. This is one of those cases that is subject to early discharge from probation. So you can talk to Mr. Carlson about it if you don't understand the advisal. Fines and costs are $640. There's a $75 prosecutor's fee, $100 in restitution payable to Kingsford Public Safety. Crime fund fee is $75. The justice system assessment fee is $50. It's a total of $1,240. The recommendation is for $150 a month, starting March 1st. Can you do that?
I have money with me, Your Honor, to pay today.
All right. Good for you. I'll order that be paid in full today then. 20 days in jail, 1 day credit, 19 days suspended if you complete 38 days on the sober link. I see them as independent and distinct of one another. In regard to the vehicle, that's going to be something you need to do each time you step in the vehicle. However, the sober link is something you're going to be blowing into approximately 6 times a day for the next 38 days. All right, I'm going to order that you attend the Alcohol Highway Safety Program as recommended. In addition, like I said, to the general terms of your probation, which are listed as 1 through 7 on the top, the following are specific to you. You must absolutely abstain from the possession or consumption of alcoholic liquor in any form whatsoever. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that are not prescribed to you. You must avoid all people that use, sell, or possess those items. Do you have a medicinal marijuana card?
I do not.
All right, unless or until further order of the court, do not use or possess either medicinal or recreational marijuana. You're subject to random breath tests and drug screens while you're on probation. Refrain from entering or remaining in places of business where alcohol is sold for use therein, excluding during the course of your employment and during your hours of employment at the T&T Steakhouse. If I didn't say it, random breath tests and drug screens. Do you understand the terms of your probation?
I do, Your Honor.
And did you understand your appeal rights?
I did.
All right, then. Mr. Carlson, anything?
No, Your Honor, thank you.
All right, good luck to you, Ms. Kitzman. Please wait for your paperwork.
22nd. The time is 9:06. My name is Carolyn Stapleton. I'll be the chair of the panel today. My colleagues are joining us by Zoom, Mr. Steve Prater and Ms. Jerry Ledoux. Is there any staff where you're at, sir, at Orleans Parish Prison?
One right outside the door.
Pardon?
They got one outside the door.
Okay. They're right outside the door. They can come in and introduce themselves for the record.
Yeah, you want me to call them in?
That's okay. Normally they're inside. Okay. Well, will you introduce yourself and DOC number for the record, please?
My name is Sean Dennis. My DOC number is 729-679.
Okay, and to repeat, our remote location is at Orleans Justice Center. Do you have a questionnaire in front of you, sir?
A questionnaire, no ma'am.
Yeah, they'll put it up on the screen.
you say, ma'am?
They're gonna put it up on the screen.
Yeah, I have that paper. I'm sorry. Yeah, I have that paper.
Okay, well, based upon your answers to this questionnaire, you are not eligible today for appointed counsel. All right, you have people here today in support of you. A Miss Miguel, and then a Miss Judy Palmer, which is your mother. The person taking lead for your case today is Miss Jerry Ledoux. She will answer your question. She will ask you the questions on your revocation sheet. You will answer guilty or not guilty, with or without a statement. Ms. Ledoux, did you want him to start off with his support first?
No, ma'am, I'd like to get the pleading out of the way. Mr. Dennis, I'm going to read the allegations against you and then give me a plea of guilty, guilty with a statement, or not guilty. Condition number 4 says you failed to refrain from criminal activity. You were arrested 8/29/25 by NOPD and booked with domestic abuse battery, with child endangerment, that there were marks on the victim's body. And on 10/28/25, the charges were refused because the victim recanted. So what is your plea to that?
Not guilty.
Number 6, you failed to work at a job that was approved and you could not provide evidence of employment. What is your plea?
Not guilty.
Number 10, you are currently behind $758 paying your fees for the Department of Correction. How do you plead?
Not guilty.
Okay. So you had a job?
Yes, ma'am.
And your parole officer knew you had this job?
Yes, ma'am.
Was it a job that you got a paycheck for?
Yes, ma'am.
So why would he say you didn't have a job?
I don't have no idea, ma'am. I was working at the Blue Crab on the lakeshore front. Lakeshore Drive. I was working at the Blue Crab. And he knew I had a job.
Okay, and you're not behind in your fees?
Yes, I'm behind on my fees, man.
Why did you plead not guilty?
Because at the same time, like it's like I was paying bills, you know, I was providing for myself at the same time. It wasn't that I wasn't trying to pay him, but it was like, you know, it's hard out there. I wasn't getting paid that much.
Wasn't like you were not trying to pay him, you didn't pay them though, right?
I couldn't pay him. I'd have been homeless at the same time.
Okay. The victim of this crime is on with us today, and I would like to have Miss Miguel speak to the panel.
Good morning.
Good morning.
Need
What
me
would
to
you
make
like to say?
I was just wanted to say that it was a misunderstanding. First of all, it was a little it started off as just a heated argument. He did grab me, but it wasn't to hurt me. I don't feel he would hurt me. I've been dealing with Sean for a while now, and this is the first time it ever got that escalated to where we had to even get, call the police or anything like that. And it wasn't intentional. I felt it like I was upset. I was just upset, and emotions and passion. When you're upset, your adrenaline rushes. It just was a misunderstanding. As far as the child endangerment, my daughter was not present for the physical when he grabbed me. She was not there with that. She just was there present when the argument. She entered the room when the argument was escalated. That was the only involvement she had. As far as Sean, he was working, and also supposed to start CDL classes with Job One this January, and he was starting that process as well. He was doing good. I didn't want this situation to defer him from being on the right track because he was.
So did you file a police report? Because
No, it
I
wasn't. It
watched the
was.
video.
Yeah, it was.
I
It
watched the
was. I
video.
was upset, and he grabbed me. It was aggressively, but it wasn't to where it hurt me. I didn't explain everything at that moment because I was just frustrated and just wanted to just of him to just go at that moment. But I wasn't trying to. I did want him to leave, but I did. He did grab me, but I didn't want. It wasn't to where he tried to physically hurt me. He didn't hit me or punch me or anything of that nature.
And they said strangulation. So
He grabbed. Well,
what?
he grabbed my shirt, and I did have a mark, but a day or two before that, I was on in the car with a friend, and she had to do a sudden stop, and the seatbelt was around my neck, and I did have a little line going down my neck, and I that probably by me not explaining that because in the heat of the moment that wasn't running through my head. I think that was documented as if he just grabbed the top of my shirt, and it wasn't like a strangulation. It was just a grab and and lift me up. It wasn't a, a hit or anything of that nature.
Okay. We also have Judy Palmer, your mother. Ma'am, if you'd like to make a statement to the panel. I'm sorry, you're on mute.
Good morning. How you doing?
Good morning. Good.
I just wanted to reiterate, Sean was on the right path. He was working at the time this incident happened with him and his fiance, which I don't know what happened, what transpired because I wasn't there, but I'm speaking on his behalf that he was working. And before then, I moved to Texas, and when Sean, I spoke with his parole officer, stating to try, to get him out the environment, living in New Orleans because he no longer have like, immediate relatives that he can, stay with, like far as me, so he can start all over again. His parole officer, gave him a hard time stating that he has to stay in Louisiana. And that's the reason why, he's still in Louisiana, trying to work, But he's been working, he's been trying to be a model, person living in society and, working. Like, I don't know why his parole officer know he had a job. So I don't know why he put that in documentation that he was not working. And, working for a certain company, you don't get paid that much money. And, he even iterated, I told him myself, if I have to, I probably can help you, sometime, pay your fee. But at the time, I'm struggling. He's trying to, start over in society because he's really starting over. So it's not like that he's gonna be able to like pay everything out or give him a big payment. But he was on a path of trying to, pay this his parole officer money. But he was working and stuff. The parole officer knew he had a job, and he was trying to be a model citizen, after they released him.
Okay. I will let you know it's not the fault of the parole officer that he couldn't go to Texas. There's certain process.
I know
Mr.
I'm sorry, but I had spoke with, the Department of Texas, and he would say, they had told me the process and everything.
Okay, good. Okay. Mr. Dennis, have you started an interstate compact to go to Texas?
No, I never received one. Me and my parole officer talked about it. He was saying that he had to send paperwork off to Texas and it take up to 2-3 months for it to happen, for the impact to happen.
Okay, so did you pay the fees for the interstate compact to be initiated?
He never told me about a fee for interstate compact.
Okay. Mr. Where do you want to live?
Huh?
Where do you want?
Spring Rain, Texas.
So what is your relationship currently with the victim?
Well, that's my child's mother at the time, man. and I love her. I'm not gonna lie. I'm in love with her. So, you know, man, you know, we get it, we fuss and whatnot, but at the end of the day, like it's I love her.
Okay, so here's the dilemma. If you go to Texas, you can't come back and forth between Texas and Louisiana without permission. So where do you want to live? Texas. Okay. Well, okay, I feel like I know what I'd like to do. So I'd entertain my colleagues to ask any questions they may have.
Mr. Prater?
Okay, Miss Miguel, is that the way you say your name?
It's Miguel.
Miguel? Miss
Yes.
Miguel, tell me, I'm just curious about the fact, according to the report, you said you told the police he choked you till you almost passed out.
Well,
And
no,
they,
I remember, well, I recall when he asked me, did I lose consciousness or anything? I told him that it wasn't aggressive. I mean, it wasn't forceful enough for me to lose consciousness. He just grabbed me.
but that's not what the report says you told the police.
Well, I don't know if they misunderstood, but from my initial conversation that I remember with them, they asked me specifically, did I lose breath or anything? And I described that I didn't. It wasn't enough force for me to lose breath or pass out.
Okay, so you got the marks. You got the marks on your neck and all that from a car wreck?
No, I had one line. It was I was in a car and they made a sudden stop and the seatbelt was pressed on my neck. But it wasn't a mark. It was just that mark on my neck, a line going down.
From a day or two before?
Yes.
Was it a car wreck or just stopped at a
No, it was
stoplight?
almost. It could have been, but good thing she was vigilant enough. She was able to stop it. But it came pretty close to where the seatbelt was pretty, tight around me.
Okay, I don't have any other questions.
Well, I'm just gonna follow Mr. Prater for a moment here. You know, they had body camera on you. They were videotaping everything you said. So we know exactly what you said to the police officer. And it was that no, he did not choke you to unconsciousness, but yes, he was strangling you. And then the other thing was the child. The child was in the video trying to explain what she had seen also. So everything now that you're discounting was exactly what the police officer wrote in his or her report. And it backed up what the body camera showed us you saying to the police officer. So you are telling a very different story than what you told them.
Well, I'm not. I probably was more as far as my daughter saying what she was just expressing when she saw the verbal. She didn't see anything physical. She didn't express anything physical. And as far as me not explaining, I maybe was not verbalizing myself at the moment because I was upset, but I did let them know that I wasn't unconscious. He did grab me by my shirt, and the shirt was around my neck, but his hands didn't physically go around my neck.
No, you did answer that. You said that he did not strangle you to unconsciousness, but that he strangled you, but not to the point of
Yeah, that's what I said. I probably
and choking you, and that's what's in his report. So his report is accurate. So really, based upon what you're telling us now about a seatbelt being around your neck, and none of this really happened, is contrary to what you told police officers who were called out to your house last night and fearful someone was being injured.
Well, I'm not saying that nothing didn't happen. I did. I just wanted to state the fact that I didn't say about the seatbelt or anything at that moment with the cops because it was a heated moment and that wasn't on my mind firstly. And secondly, I'm not saying a different story because everything happened. It wasn't as intense as I probably was very upset. So it was more, I probably described it as a little more intense than what it was, because I didn't want this to defer him, because it wasn't a situation to where he's violent towards me on a daily basis. This is a norm for me. That's why I just wanted to express that, because I don't want that to be a factor of him not being able to be free, because that didn't happen that way. I just wanted to convey that. That's why I came, because I didn't want that to be a factor in him not being able to continue to do what he was doing, because
I got you. I got you. I'm going to pass it to Miss Ledoux so that she can speak.
I'm gonna go ahead and vote, because I do believe that there were some violence. The charges have been dropped. My vote today is in lieu of revocation to send you to the domestic abuse battery program within the confines of the Department of Correction. And that will give you an opportunity to start your interstate compact to go to Texas, so that you would have no contact with your victim, and supervised transfer for your child, so that you can see your child, but with no contact with your victim. And so that's my vote today.
So you're revoking my parole?
Okay, so the term is in lieu of revocation. It means you're not totally revoked. You would stay in the Department of Corrections custody until you've completed a 6-month, it's about 6 months, domestic abuse battery program. And then you would be released. And I am hoping that you have your interstate compact taken care of by then, but that you would have no contact with your victim.
Mr. Prater.
Hey, that sounds reasonable. My initial thought was to go ahead and revoke him, because I think that lady's lying. And in fact, I think it's pretty evident that she's lying. And I think he's got violent tendencies, but maybe this domestic abuse battery or this will help him by going through this extended period of incarceration. So I concur with Ms. Ledoux, bottom line.
I also concur with Ms. Ledoux, because certainly I agree with Mr. Prater also. So as of today, sir, you have been, in lieu of revocation, you will be enrolled into the, it's a long-term program, up to 26 weeks, domestic violence vendor program. And then you would have no contact with your victim. So this concludes your hearing at 9:26.
Mr. Miller, we only have, I think, this may be the last case before yours. Mr. Sherman, good morning. Mr. Sherman, you're here because you've been accused of 1 count of possession of methamphetamine, 1 count of possession of drug paraphernalia, a possession with intent to distribute methamphetamine, and a driving while license suspended or revoked knowingly. Those are the 4 charges you're accused of. So I have read the complaint this morning. There is probable cause. I've also looked at your criminal history, which is not bad. There's a violation of a PTI, but it doesn't show me the disposition when you went back to court on that charge, but that's the only thing that's on here. So I think you're entitled to a bond. Let me see if I'm missing anything. Mr. McDaniel, anything on behalf of Mr. Sherman?
No, Your Honor.
Mr. Mitchell?
We just request he be subject to random UAs.
Mr. Sherman, you're not on bond now, correct? I mean, you're not on probation now, are you?
No, sir.
Okay. Mr. Sherman, I'm going to set your bond. The most serious charge is that possession with intent to distribute. That bond's going to be $10,000. The methamphetamine is the same methamphetamine. Now, I researched that this morning, and the case law says that you can charge both. I don't know the state normally does, but you could. So that's going to be a much lower bond because it's the same substance, the exact same methamphetamine. You're charged with possession with intent to distribute it, and you're charged with possession of it. At one time, you couldn't do that, but the most recent case I found says that you can out of Florida. So your bond on that possession of methamphetamine is going to be $1,000 because you've got the bond for the same substance. Drug paraphernalia and the driving license suspended will be $2,500 each. When you add those together, and I didn't write down what I said on the $16,000 cash or surety, Mr. Sherman. You do have a condition of random urinalysis, sir, because it's a drug offense that you're accused of, and you will have the right to use the phone in a few minutes to try to post the bond. They will give you your notice at the jail for your court date, which should be February the 3rd at 8:30. Mr. Sherman, do you have any questions?
No, sir.
Wish you the best, sir. I believe we've got Mr. Miller that's been waiting. Mr. McDaniel, we'll come back to those other couple of cases in just a second. Mr. Miller's client's in the courtroom here, and his name, Mr. Miller?
It's Jake Hodges, Your Honor.
Mr. Hodges, come on up, please. This is State of Florida versus Jacob Hodges. Mr. Hodges, Mr. Miller has been very proactive in trying to get your case resolved, so he's got it set for a plea hearing today. You're hearing case number 25-483CT. I'm going to ask Mr. Miller to put the specific charge or charges on the record and listen to your attorney, please.
Yes, sir. Your Honor, Mr. Hodges is charged with 1 count of DUI. His offer is 11 months, 29 days probation with $1,078 court costs and fines. He'll have to complete the DUI school. He'll have 50 hours community service work. He'll have the minimum driver's license suspension, and he must enroll and complete an inpatient drug treatment program, and that inpatient portion needs to be 90 days.
So, Mr. Mitchell, here's my question. My understanding just from the emails I'm reading back and forth is if he successfully completes the inpatient portion of 90 days, he'll be eligible for immediate termination of probation as soon as court costs and fines are paid.
Yes.
Is that correct?
Yes. Wait, say that again.
Okay, so look. So I don't know if you can hear. I'm gonna make sure he can hear you, Mr. Goodson. Mr. Goodson wants to make sure we're all on the same page, Mr. Miller. So so that's a great point.
Can I say something real quick? Corporal Campbell, can you mute the mic out there? I'm sorry, I'm getting a lot of feedback and I can't hear Mr. Miller.
I apologize. Sorry. No problem. Thank you, Corporal. So, Mr. Goodson wants to make sure that what the conditions are you've got to complete before you get probation, before you get off probation. You clearly got to do the 90-day inpatient drug treatment. You clearly got to get the court costs and fines resolved. Okay. You also, by state law, have a condition that you do 50 hours of community service work. I'm going to give you credit for that for being at the program as long as you complete the program.
Yes, sir.
So you won't have to do the community service. But what you will have to do is enroll in DUI school, complete DUI school to get off probation early. Okay?
Yes, sir.
Is that, I know that we may not talk through all of that in these texts. I'm not sure if you were aware of all of that. Does that bring any questions to your mind or any hesitation in entering this plea?
No, sir.
Mr. Miller, any concerns that you have about those clarifications at all?
No, Your Honor.
So I have no problem you getting off early. I have no because you're doing the 90 days. I have
Yes,
no problem
sir.
you getting off on day 91, as long as you have got other things done. And the problem is you can't do the DUI school until you get out of the program. So you're going to get out of the program, take care of the court costs and fines as quick as you can, get the DUI school taken care of, and then you're going to be eligible to get off probation immediately when those things happen.
Can the fine money, can that come out of the cash bond?
If there's a cash bond, we have to take it out. So how much is the cash bond that was posted?
5,000.
Okay. So what happens is the court costs and fines will be taken out of the cash bond, and the balance will be returned to whoever posted the cash bond, whoever's name is on it. Mr. Goodson?
So we did this last time. I don't know if Mr. Hodges wanted to do that. So hypothetically, if he stays on 90 days, which I think will be longer, would he want us to go ahead and take 3 months of probation fee out of that?
I don't want him paying supervision fee while he's in the program.
Okay.
Okay.
I mean, y'all not doing anything. He's in the program.
Well,
I say y'all not doing anything. I mean, the probation isn't actually doing an act of supervision because you're in the program. Now, once you get out of the program, your supervision fee will start, your monthly supervision fee. So what you want to try to do is aim to get everything taken care of when you get out of the program, so you've got everything done. So you're on probation as little time as possible after you complete the program.
Yes, sir. The program I was going to is in North Georgia.
Okay, that's fine.
And I'm going Monday.
Okay, we're going to talk about that in just a second. I'm
Yes, sir.
sure the attorneys have discussed that, and I don't know that I've seen that in the email. Mr. Miller, what's the plan on getting him up there? I think your email may have said bars to bed at some point, but I could be wrong about that.
Your Honor, that is the bars to bed issue was regarding the inpatient drug treatment to the aftercare. So they call it door to door. So once he's done with the first 45 days of inpatient treatment, he will be door to door transferred to the aftercare facility that's also inpatient, which is somewhere
So
from
the agreement
45 to
that
6 days.
The agreement that y'all have reached between yourself and the state and your client is he would actually go home today and he's going to self-report to this program Monday?
Yes, sir.
Mr. Miller, is that accurate?
Your Honor, I don't know that me and Mr. or ASA Mitchell have discussed this specifically. I think at the last court date, what he was the position of, as long as the 90 days got completed during probation, he was comfortable with that. Am I correct in that, ASA Mitchell?
That is correct. I think just the issue is just him getting there, which
And I don't have a problem with that. I just want to make sure we're all on the same page.
yes.
What time will you be reporting Monday?
Will
Do you have a
leave
report time?
well, they're 24. She said that they're 24/7. I mean, I can come.
I need a time.
Oh,
Because we're going to check and make sure you're there.
yes, sir.
Because that's going to be a condition that when you meet with the probation officer today, he's going to say, when are you going? What time are you going to be there? Because they're going to make sure you're there. Because if you don't
Yes,
go
sir.
to the program, that's going to violate your probation.
Oh, yes, sir. I'm
So
going.
what time do you have to be there Monday?
Um,
Where's that in Georgia?
It's in Monroe.
I don't know where Monroe's at. Is that North Georgia?
It's right outside of Atlanta.
Okay, so it's 5-6 hours away. So, and you're going up Monday morning or you going Sunday and then be there Monday morning?
We were planning to go Monday. We were going to leave early in the morning and
Okay.
he was going to take me up
Who's
there.
taking you? Is that your father?
My father.
Is your dad taking you?
Yes, sir.
Okay. You want to stay 3 o'clock? I don't-
3 o'clock Monday.
3 o'clock our time. Okay, so if we say 3 o'clock, that gives you time to get up there, get something to eat, get him situated, go to Walmart if you need to get stuff or whatever, and then I'm not, encourage you to go to Walmart, wherever you want to go. I couldn't care less, but he may need socks or whatever, so 3 o'clock Central Time Monday, you have to be at the program. Mr. Miller, can you live with that?
I can, Your Honor.
Mr. Mitchell?
That is agreeable with the state. I did also want to say that this agreement is the law enforcement officers that were involved in this are agreeable to this plea.
And I appreciate you wanting to address any underlying issues that may exist, okay?
Yes, sir.
And is this a plea you want to enter?
Yes, sir.
All right, I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to ask you to sign this waiver of rights form. This form, Mr. Miller's probably explained to you already. I'm confident he has. This form waives your right to a trial. It also waives your right to call and cross-examine witnesses at that trial, Mr. Hodges.
Yes,
You sign your date of birth. Mr. Hodges, I'm going to accept that plea of no contest. The judge, you're guilty of the offense of DUI, place you on probation for 11 months and 29 days. Court costs and fines of $1,078 to be taken from the cash bond. The balance of the cash bond will be returned to whoever posted it. You have the conditions required by state law, which are successfully complete DUI school, which I've talked to you about, successfully perform 50 hours of public service work. But since you're doing an inpatient treatment program, as long as you stay there, and complete the program, you'll be given credit for the time there, and that will satisfy your community service work obligation. I do recommend the minimum driver's license suspension, and it's a total of 90 days. Mr. Miller has been clear that the initial inpatient portion is only 45 days, I think, but there's a follow-up aftercare that's also inpatient, and I've told the attorneys I have no problem with that as long as it's inpatient. So you've got to be somewhere at least 90 days dealing with the underlying issues. Once you get out, cop supervision very well may start, but you will only be on supervision until you get those conditions completed. Normally people have to do half their supervision. In your case, you may not even have to do half. You may want, you'll talk to Mr. Goodson downstairs. You may want to go ahead and schedule the DUI school at a short time after your release. That way you've already got it scheduled. And when you finish the program, you'll have that already scheduled.
Yes, sir.
But that's something you'll talk to Mr. Goodson about. Lastly, you'll report to the program next Monday. What's that date? January 26th, no later than 3 o'clock p.m. Central Time. Mr. Hodges, do you have any questions?
No, sir.
Mr. Miller, did I miss anything from your perspective?
No, Your Honor, but I do want to make sure that I'm clear about one thing. Once he gets out of the program and the supervision starts, how long does he have to check in to probation?
Well, where do you live at?
I live in Donaldsonville.
Okay, what I'm gonna say is the next working day.
Next working day.
Okay.
Okay, so if you get out on a Saturday or even a Friday, you know, you got to report in the following working day. So if you get out on a weekday, you got to report the next morning, next day. If you get out, they'll give you the hours downstairs. They're open 8 a.m. to 4:30 p.m. But it's going to be the next working day, and that's just to check in and make sure you're on the same track. Everybody wants you to get this done and complete it and get all probation and get it behind you.
Yes, sir.
Okay. Any questions?
Just, will I get a copy of the order?
Yeah, you're going to get a copy of everything in just a second, and you're going to see Mr. Goodson with the probation office, and they're going to get you downstairs and get you instructed. They're going to go over everything with you, answer any questions you have, give you a copy of everything in writing, and then you'll be free to go.
Yes, sir.
Let me see if your dad has any questions. Sir, do you have any questions?
No, sir.
Well, I hope you complete everything. I wish you the best. Okay.
I need it.
Thank you, Mr. Miller, for getting this on the docket and getting it resolved. Appreciate it.
Absolutely. Thank you, Your Honor, for doing it on such short notice. And Mr. Hodges, if you have any questions, give me a call, even if you're down in probation, okay?
Yes, sir.
Thank you, Your Honor.
He
Thank
said
you.
yes, Dustin.
We have a couple of more cases of Mr. McDaniels. I think both of these maybe, actually one of them is not Mr. McDaniels. Let me take Mr. McDaniels' last case, State versus Robbie Mickens.
Your Honor, we have a small problem. Ms. Garcia? Judge Garcia?
Yes.
All right, we're doing a hearing here at the jail and you dialed in. Can you disconnect us from the?
Sorry, got to interrupt because Lindsay steps in with 2 more $10 super chats to get us to the goal. We've never done a super chat goal here at TCF in the 15 months that we've done the channel. So I just wanted to try it and see what would happen because we haven't done it before. And the generosity has been amazing today. I really appreciate it. You know, you guys always have my back and it means a lot. And Lindsay, you've really stepped up today and been super generous. And that's very sweet of you. And I appreciate you. I hope you know that. Very much appreciated. But as promised, in my hands, 1 can of chunk white albacore tuna. The cats love this. This will be their snack tonight. I'll try to catch some pictures or videos and we'll post those on the channel just as proof of following through. But again, your generosity has been great, as always. I mean, I've said it before, though. You guys don't owe me anything, but you're surely appreciated. And I just want to say thanks. So back to Judge.
Your assets that total $350. Does that sound right, Mr. Mickens?
Yes, sir.
How long do you request after you complete your sentence to have to pay that fee? How long do you think you need after you complete your sentence?
Within a month, sir, the very next, my very next benefit date.
What I'm gonna do is give you 60 days from when you complete your sentence to get those court costs and fines paid. Excuse me, it's not court costs and fines. It's a special assistant, the public defender fee. So 60 days, that 60 days doesn't even begin, Mr. Mickens, until you complete the sentence. Mr. Mickens, do you have any questions?
No, sir.
All right, sir. Thank you. Wish you the best.
So.
We have State versus Randall Pittman that Mr. Mitchell has requested to be added to see where we stand in that case. Mr. Pittman, your case is set for trial, and Mr. Mitchell's added you to the docket today to make sure that was still your decision, because I think the offer to you today would essentially be a time served offer.
Yes, Your Honor. And that's why I requested to bring him back up, see if he wanted to go ahead and accept the time served offer. If not, we can just leave him on the February pretrial date and the trial date.
So you're set for February pretrial and trial. If that's what you choose to do, Mr. Pittman, that is perfectly okay. But the offer they made to you, or that was made to you, was 60 days.
Yeah.
And now that you've done 60 days, essentially it's a time served offer, which means if you decide to take the offer, and I think there was a plea to one charge and the other charge will be dismissed.
Yes, 575 MM would be dismissed.
So that's the offer that was made to you. I'm not suggesting you take it or not take it. I'm just making sure you're aware of that. That is essentially a time served offer at this point. Is it still your choice to go to trial, or do you want to accept that plea offer?
Well, at this point, I want to request counsel, because the state, they're not serving me with any documents.
They're making it sure that I don't even see what I'm being charged with. And there's no way anybody can win in that kind of situation where you don't even know what the charges are or what's going on in the case. So I would
And
rather have
Mr.
a public
Pittman,
defender so that I can at least
I don't
have
disagree with that. I don't disagree with what you're saying at all. That's why I've encouraged you to accept the services of an attorney, because you have to file certain intent to participate in the discovery process. And once you do that, they have an obligation to give you the information you're talking about. So you're requesting an attorney for, at least for now, to get an attorney appointed to represent you, correct?
That's correct.
I'm going to appoint the public defender's office to represent you, Mr. Pittman. And so what we're going to do then is, for right now, you're still on the trial docket. Obviously, Mr. McDaniel needs to talk to you, and then he'll bring you up on an appropriate court date. But right now, you're still set for the same court dates you're previously set for. Mr. McDaniel, if you're able to reach some agreement, please let us know. If there's other motions or issues that need to be dealt with, Mr. McDaniel, please let us know that. Mr. McDaniel, anything else for Mr. Pittman?
Nothing else, Your Honor. It is some more time. It's kind of a surprise to me, so I'll talk
Me
with him
too.
and see what we figure out. So, yeah.
Thank you. Mr. Pittman, we'll see you soon. And I believe that's it, except for Mr. Whitaker. Mr. Whitaker?
John's talking to him right now, so there may be a possibility he comes back up. I don't know. We'll see.
Come on up, Mr. Whitaker. I don't see any paperwork in your hand. All right.
He's hiding it on us.
Let Mr. Mitchell see that while we're waiting.
And
All right,
while
so
we're
we're
waiting,
hearing-
while they're waiting, results of the poll, a little bit of both. So since we are at pretty much at the top of the 4th hour, we'll do 30 more minutes of court, and then at the bottom, you guys can call in and chat about what you saw today or whatever. Again, there's a link in the Discord for channel members to do that. And I've got a couple of court-related news stories that we can go through as well, and maybe some commentary on what we see here. So that's what we'll do, per your request.
Of the possibility of it costing him his job, which he's had for 2 years. So instead of doing that, we set a sentencing for today. Ask Mr. Whitaker to bring in some documentation from the employer about his employment, and we would go from there. Is that what you have with you, Mr. Whitaker? Yes, sir. Can I see that, please? Mr. McDaniel, I'm assuming you've not had a chance to see that?
I have not, Your Honor, but I don't need to see it. I mean, I just let the court review it.
It's U.S. Foods verification of employment. To whom it may concern, Michael Whitaker is currently employed full-time with U.S. Foods as a night selector. Mr. Whitaker's date of hire was April 8, 2024. Should you need additional information, please feel free to contact. And there's an email and phone number on here for this person. And what is Mr. or Miss Adams? They don't say their role. What is their title? Who is?
He's the HR manager. I have
This is
the
a she?
email. I have the email if you want to
It's
see.
okay. I'm just trying to see. It doesn't say her role on here, which is a little unusual. Okay. This is the person we tried to call in court. We weren't able to get a hold of her. Okay. So let's put that in the court file. So Mr. McDaniel and Mr. Mitchell, to summarize my memory, I watched the video again this morning, but driving record's horrible, but most of it was older stuff. This was a 2020 case, 5 years old. He missed his court date, warrant's been active for 4+ years. He gets arrested in a neighboring county, Madison County, perhaps?
Madison County.
For the same thing in Madison County. When he resolves that over there, either by bond or release, he sits there about 9 days, comes over here, gets a bond set, or at some point posts the bond, and then shows back up for arraignment. Procedurally, that's what the video this morning I watched seems to reflect. But Mr. McDaniel, as I said, someone's had a job for a year and a half. I wanted a little more information before I did something that may cost him that job. So last thing is, when he entered a plea, it's a first-degree misdemeanor he pled to, which carries a maximum penalty of a year in jail. The state's recommended offer, before we knew anything about all that information, and the employment was what, Mr. Mitchell?
The previous
60
offer?
Yes, sir.
It was 60 days.
Okay. All right. So, Mr. McDaniel, let me hear from you first. Anything you want to make sure I'm aware of or emphasize?
I think we went over everything at the last hearing, if you recall, so I don't think it's a whole lot more. Just to let you know, he's got 9 days jail credit on this charge. And that's, I don't think there's anything else, Your Honor. We just asked the court to sentence Mr. Whitaker.
Mr. Mitchell.
Your Honor, I will clarify that the offer that I originally made, 60 days, at the time, the Madison County case was still open in the felony portion is what it is. Since then, it looks like it has actually been transferred down to county court over there. So that's the reason why I made that offer right there. I think he said he had 9 days credits.
Is it still unresolved?
It looks like it's still unresolved. It looks like he's been given a court date for 2/23/26.
9 days credits, what Mr. McDaniel, or he told us, he actually is the one that said that. Anything else?
I mean, that's pretty much it for right now.
So, Mr. Whitaker, you got a choice. Choice number one is to say, I don't want to do probation. I just want to go ahead and do my 60 days and get it over with, get credit for 9 days and do it. It may or may not cost you your job. You know that situation better than I do. Choice number two is to say, I'm going to do probation. If you take choice number two and I give you a shot at probation, and if you make it, it's great. Everybody's happy. But if you get probation and you don't make it, and there's a substantial violation, there's a high likelihood I would sentence you to more than 60 days in jail. More being somewhere between 60 days and the 1 year maximum. So the question really is for you to decide how likely is it that you can make probation?
I can do the probation.
Okay, so you're requesting the probation alternative instead of the 60 days in jail, is that right?
Yes, sir.
Mr. McDaniel, anything else?
Nothing else, Your Honor. And I mean, probation to go over everything with him. And Mr. Whitaker, it means you got to comply with everything, pay the fines, send in the emails, responding to the probation officer. You need to stay in touch with them. Take it serious. No drinking alcohol, no using drugs. It's all part of probation. So just understand that.
No driving without a valid DL also,
So, Mr. Whitaker, when someone's had the same job for a year and a half, that says something about their work ethic. Okay, so I appreciate that. That's the only reason I'm considering a probation is because you've got a job and that says something, and I don't want you to lose that job, frankly. They're maybe hard to come by right now. So what I'm gonna do is, I've already accepted your plea of no contest to the charge of driving while license suspended or revoked knowingly, second or subsequent offense, a first degree misdemeanor. I'm going to withhold adjudication of guilt. I'm going to sentence you to 11 months and 29 days probation. Mr. Whitaker, you will have the standard conditions of every probation, plus the following special conditions. Court costs and fines, there'll be the standard amount for this charge, which is $400. You have a condition that you not drive a motor vehicle unless you have a valid license. If you get a valid license, you drive all you want. But if you don't have a valid driver's license and you get caught driving without license, that's going to revoke your probation. You also have a condition that you obtain a valid driver's license if one is reasonably available to you. What that means is some people have to pay thousands of dollars to get a license because of something that happened years ago, and they just simply can't do it. Other people, all they got to do is pay a reinstatement fee. So if you can get a license, you're going to be expected to. If it's too complicated, too expensive, then you can't do what you can't do. And I'll put a note in the system when I told you about making probation and your offer being 60 days, and I want you to succeed. The last thing Mr. McDaniel mentioned, I need to make sure you understand, is when he mentioned emails, because of where you live, you won't report every month. That's not practical. What will happen is every month you will send in an email that is a form they're going to give you downstairs, and that email will constitute your reporting. You can do it by email or mail or regular mail, but instead of reporting in, you're going to send that in every month with any payments you want to make. And you won't have to come back here every month.
Okay.
As long as you do that. Now, if you don't send that email or mail in, that will violate your probation. If you get caught driving without a valid driver's license, that will violate your probation. If you don't pay your court costs and fines, that may violate your probation. If you get charged with a new crime somewhere, that'll violate your probation.
I have a question.
Yes, sir.
What's the total of the court costs and fine?
$400.
That's it. I can pay it today. That's fine.
You can, if you pay today, you don't have to worry about that. Now, you do have what's called cost of supervision, which is $40 a month, but that's only for the months that you're on.
Okay.
So I want you to try to get everything done at the 6-month point so you can get off early.
Yeah.
So you would only pay 6 months of that. You obviously wouldn't pay for the months that you're not being supervised.
Okay.
So you have the $400 and you have the cost supervision. That's it.
Okay.
Okay. Any other questions?
No, that's it.
All right. So I think I went through the whole sentence, didn't I? So what we're going to do is I'm going to give you some paperwork. I'm going to get you to see Mr. Goodson here. Mr. Goodson is with the probation office, and Mr. Goodson will get you downstairs and get you instructed. They'll give you all the rules in writing. They'll give you a chance to ask any questions you have about those rules, and then you'll be free to go. Just remember, every month you've got to either send that report in by mail or email or come in person. That's up to you. But considering where you live, you're going to get the option to do it by mail or email if you want. Any questions for me?
No, sir. That's all.
I wish you the best. See Mr. Goodson over here, okay?
He's ready for that snowstorm.
at the freezer.
Oh, yeah, they got ice storm coming up there, don't they? Yeah. All right, so Mr. McDaniel, that's everything I had on my docket this morning. Anything else from the public defender's office?
Okay, that's everything he has. We'll move on. Again, just a reminder, it is the 4th hour, so normally you just listen to me chat right now and complain about things. But because that hearing in Pontiac chewed up so much of the time, we're going to do the first half hour here of more court, and then we'll look at some thoughts and commentary and court news and stuff after that. Let's go back to Judge Stevens.
It's called Your Willie Coward? Yes. All right. And the state and the defense are both here. There was a motion to revoke probation that had been filed back in 23. The defendant pleaded true in June of 25 to violations which were not substantive, but were failing to report properly to the probation office. So we continued him on probation. Here's a review. And from probation, how are we doing?
Your Honor, after the last court appearance, you had advised Mr. Coward to, if at all possible, to pay the restitution in full. And Mr. Coward did do that.
How much is that?
He paid $3,569.12, which finished paying the restitution in full. The case
Happy as a lark. Yes.
The case was originally set for May, and so I sent a memo to you advising that the restitution had been paid. He is continuing to report monthly to Ms. Young. He does reside in Vidor with his brother and sister-in-law. At that time of the last court date, you had advised that you would be willing to consider other a lesser restrictive community supervision.
What else do we need to accomplish on probation?
Mr. Coward.
Because he's on, just not to interrupt you, but just for the record, he's been on probation now for over 6 years.
Mhm.
And if they do well, of course, we can shorten probation. And that's my question. Is he worthy at this time?
The majority of Mr. Coward's time on probation, he has been incarcerated within TDCJ. Mr. Coward.
Did he successfully complete that incarceration without
Yes, sir.
parole revocation or anything?
He was paroled and that was revoked.
Okay, while he was on this,
Yes, sir.
okay. But he has been paid that price that was assessed in
Yes,
that particular case. On this one, what other conditions is the probation office is the probation office stating needs to be accomplished?
The only concern that we have is Mr. Coward does have some medical conditions. As of January the 6th, he did submit a drug test that was positive for his prescriptions as well as methadone. That's the only issue that I see at this point in time. We are prepared to, if you allow him to go on to an inactive probation, we have an order of allowing that with some additional conditions such as reporting for random drug testing when requested, even though he is on inactive probation.
The drugs that he's testing positive for, those were not the prescribed drugs?
Not methadone, Your Honor.
Yeah. What happened there?
Well, through, I went to work with my sister and didn't have my medicine. And you get real sick on the medicine, and if you don't take it, and methadone, but the only thing that gives you any relief.
So you self-medicated?
Yes, sir.
Your Honor, that was the same story.
That's not the way to do it on probation.
That was the same story that he offered me in September of 2025 when he tested positive for methadone as well. That was addressed at that time, and we completed a substance abuse evaluation that recommended special needs safe P. But because of Mr. Coward, he's a registered sex offender, he's ineligible for safe P. Placement.
All right. Shame on you the first time. Shame on me the second time.
Yes.
If I just say, we went over this and you know that you touch the stove and it burns, why would you embrace the stove now?
Your Honor, because I thought we were talking about the first time, but I didn't know the second time. I was unaware that I tested positive the second time.
Well, you tested positive, but you would be the best person to know whether you used improperly or not. But the tests, we're going to rely on the tests unless somebody can prove that they were not administered in a correct fashion. The tests are scientific.
So I've read that the text rule, I hate give false positives on something.
We're going to rely on the tests.
Yes.
By the preponderance of the evidence or greater.
Yes.
What are you suggesting, Ms. Thayer?
Your Honor, I would offer the court two options. If you wish to dismiss the motion and continue him on probation, under a direct supervision, I would ask that you consider allowing him to report and ordering him to report directly to Jefferson County because of the fact he does reside in Orange County. We would even be willing to reduce his supervision fees half to $30, or you can place them on inactive. And if you'd like to review the inactive order that we prepared, if that would be substantial.
What do you think is in the best interest of success in this case? Closer to him. I mean, those are, to me, that's 6 of one, half a dozen of another. I don't know how to weigh those, and I trust you.
Your Honor, Mr. Short did come through with what you asked him to do. With the exception of the recent methadone positive, he reports as he's directed, even though he's tardy at times, but Ms. Lakin Young is now supervising him and she's working with him. He would be transferred to a different officer with a direct report here. I would say that having him report to Orange County would be a hindrance on him financially as well as transportation. And that would be, I think, a path for unsuccessful probation.
Okay. If we continued him here, what conditions would you add, if any?
I wouldn't add any additional conditions, Your Honor. At this time,
I'm just concerned about that, the methadone.
yes, sir.
Positive.
That's the concern because of the fact that I specifically addressed it with him on the first one.
Okay, before I do something, go ahead, Mr. Turk.
Judge, the goalpost keeps changing on this one for us.
The goalpost changed because of him.
No, sir, not on this
It
one.
was the methadone positive that's changed.
I understand, Judge, but just a couple of days ago, I got the recommendation from the probation office that they were going to recommend inactive. Now it's going to, hey, they're coming back and say, these are the test positives. Nowhere in this email, nowhere in these conversations where he's put in there. Couple with the fact that.
Guess what? They're allowed to change their thoughts.
I understand that.
Okay.
I understand.
And they're not making contracts. He made the contracts. He made the contract with me that he violated. So don't blame them.
I'm not blaming, I'm just.
Yeah, but don't criticize them under these circumstances, please. Just what's in his best interest so he can be a successful person and be productive in life and be independent.
I think at this point, Judge, he's complied with most everything that everyone's asked of him.
Most everything. It's not almost there, but he gets you the participation trophy. I want the winning trophy for all this. Okay, what else do you want? Go ahead.
I had come into the impression that this was going to be recommended inactive probation.
Sorry about the frustration, but I'm not going to criticize these people. They produce a result that is unheard of in probations, and that's 93% success rate, which we're all proud of, and we want him to bring the bar up to 94 with his success. So they're not going to get criticized on my watch. They're working hard, and they don't mistreat people. We try to even drag them across the goal line if we have to, if that's what is necessary. but I want him to be independent, to make his own right choices independently. Here's what I'm going to say. Okay. We're going to, I like your idea. And what we're going to do is we're going to continue your probation and we're going to do it that is cost effective for you. I want to review in 3 months for the termination of probation or not.
Yes.
Okay.
Yes.
And you do well, all things considered, and probation says you're doing fine, then that's what I intend to do.
Yes.
So, but let's get
Yes.
another 3 months. Also, do whatever it takes so that it's cost effective for him. So it's less costly, and he doesn't have to make those drives.
Yes, sir. I have an order.
Oh, sorry, excuse me.
Sorry.
Supervisor fees are going to be reduced $30 per month. And you're ordered to report to the probation officer in Jefferson County. We will review in 90 days or less. If you feel like we don't need to wait 90 days, let's get him free.
Your
I think you're doing good.
Thank you.
But once again,
Yes.
we want you to be on this 93% success rate, not the 7%.
Yes.
Because I know, I believe you're able to, and that's, some people are hopeless sometimes. You just know it's frustrating that they're not going to make it. You are the ones. Just make the right choices. You know what they are. That 3 looks like a 5. Here is something. Bring it back to probation. If you can, let's get a resetting for 3 months, please.
Thank you, Your Honor.
Thank you.
So real honesty there from Judge Stevens that I don't think I've heard from another judge, where he just admitted some people are hopeless.